the University of the Free State, Prof. Francis Peterson, Emeritus Constitutional Court Justice Albie Sachs, Emeritus Constitutional Court Justice Zach Yacoub and his wife Anu Yacoub, Supreme Court of Appeal Justice Yvonne Mabata, all judges from the Supreme Court of Appeal and the High Courts, including Justice Deniso and Judge Leach, all members of the Rectorate, Dean of the Faculty of Law of the University of the Free State, Prof. Serge Kamga, all deans representing other faculties of the University of the Free State, Dean of the Faculty of Law of the University of Pretoria, Prof. Alsabi Skuman, members of the legal fraternity, Senior Lecturer of the Department of Public Law, Faculty of Law, University of the Free State, Dr. Audrey Duplessis, Ms. Vanessa Rose September, Chair of the Albie Sachs Trust and producer of the Albie Collection, and Ms. Louise Pulford, CEO of Social Innovation Exchange, London. All protocol observed. Welcome to all attendees. I'm sure that as the day progresses, we'll be joined by more students and staff as they work through their class schedules and test schedules. We also have a number of attendees that's joining us on the live lecture. Welcome to everyone. I will hand over now to Prof. Serge Kamga, Dean of the Faculty of Law, to do the official word of welcome.
Thank you, Program Director. Good morning, everyone. I would like to stand on the protocol as established by the Program Director. I will start by wishing you all a happy Human Rights Month. We are immensely delighted to welcome you all at the University of the Free State. Under our Vision 130, our graduates should inspire excellence, transforms life through quality, impact, and care. Having this in mind, to celebrate the Human Rights Day, we have invited the cream of the cream of those who have inspired excellence, transforms life, and impact our country, the continent, and the world. As a student, I was privileged to be given a tour of our Constitutional Court in Johannesburg by Justice Albie Sachs. It was great to understand why the windows of the court are low and transparent, as the aim was to ensure the transparency of the proceedings in court. Justice Albie Sachs is well known for his activism and great judgment. I was also very much inspired by Justice Zach Yacoub through his speeches and his judgment. Through his brilliant work, he demonstrated that disability is not inability. Similarly, Justice Yvonne Mabata inspires excellence in a context where discrimination against women is still real. Justice Yvonne demonstrated through her work that a woman's place is not in the kitchen, but in the courtroom at the Supreme Court of Appeal. More importantly, in the South African context, not only she's a woman, but a black woman for that matter. Her experience inspires every black South African girl to aspire for the best. In the same vein, Prof. Skuman, the Dean of the Law Faculty at the University of Pretoria, has also done great work in her research and various activities. But I want to highlight that In 116 years of that university, she is the first female dean of law at the university for 116 years. If that doesn't tell you something about the light she can set, she can shine on the society to inspire other women and girls, then something may be missing if we cannot see that as a special achievement. Our own Dr. Adri Duplessis, who is a senior lecturer at the Department of Public Law at our faculty, works tirelessly, and she's very interested in Black economic empowerment. In her work, she seeks to redress the justice or inequality of the past. Her work every day consists of inspiring students every day as she's in her classroom. I want to say here, last but not least, is Ms. Vanessa September, who is the chair of the Albisac Trust and producer of the Albi collection, as Dr. Deman said earlier. She is an architect in her own right. Through her work, including teaching part-time, transforming underutilized spaces into well-functioning public spaces, she inspires many in our communities. She is a leader that cannot go unnoticed in our communities. She is another woman who inspires girls to believe in themselves and break the so-called glass ceilings in our societies. Before I zoom in the main issue of the day, namely the 30 years old of our human rights, please let's give our esteemed and honorable guest, our icon, a big round of applause. Thank you so much for your contribution. Now, I want to zoom into the matter or the issue of the day. Today, we are looking at the 30 years of the Bill of Rights of South Africa, the human right of South Africa. I will say 30 years ago, the country adopted its constitution. This constitution is characterized by a very important Bill of Rights in its chapter 2. And the Bill of Rights is unique because in many other countries, you don't see a Bill of Rights, but you see the preamble of the Constitution. And who says Bill of Rights says binding part of the Constitution, is part of the binding part of our law. And many commentators have spoken about human rights and the Bill of Rights. The American scholar known as Professor Karl Clark praised the Bill of Rights. He held the Bill of Rights so much that he characterized the entire Constitution as being transformative. However, this view is not universally applauded. While Clark says the Constitution is great, it's a great piece of work, it's transformative, and this view is supported by the former Dean of Law, Prof. John Mubangizi, our former Dean of Law, who was here before me. You have a group of scholars, such as Zanele Sibanda, Tsepo Malingozi, Joel Modire, who will argue that the Bill of Rights is not even worth the paper it's written on, to quote Justice Zak, who used that phrase in one of his very important judgments. For these scholars, they have the view that the Bill of Rights is full of neoliberal ideologies that cannot empower our people, South African people. Now, in this controversy and in this discussion, we are now celebrating the 30 years of our Bill of Rights. And the question that this celebration brings to mind is there a reason to celebrate human rights in South Africa, given the controversy, given the diverging views regarding the Bill of Rights? And this very important question will be answered by Justice Albie Sachs in his presentation today. But before we get to that, we will have a panel discussion on the contribution of Sir Kentridge, Sidney Kentridge Wolff, on his contribution on human rights, contribution to human rights in South Africa and beyond. Sir Kentridge this year will be turning 102 years old. And at this university, we have to some extent recognized his great work and contribution as a great academic and as a fantastic lawyer. He will be receiving next month an honorary doctorate from our university. So his work and contribution will be the topic of the panel discussion to be chaired by Dean Schoeman shortly after the welcoming remarks of our Vice Chancellor. Immediately after the panel discussion, we will also, I will say, we will be blessed. We will be officially receiving the Shackleton collection given to the Faculty of Law by the Albie Sachs Trust. And I will not simply mention this without thanking Vanessa, Ms. Vanessa September, who is, I will say, the architect, the initiator of this gift that I hear. Definitely, we as a faculty and a university, we are very grateful for these books, and we thank you immensely. Because when one book is donated, you can imagine how many students will read the books from generation to generation. So through you and through your action, through this donation, you will help us accomplish the vision of the university, Vision 130, which seeks to ensure that this university transforms people's lives, build the country, and empower people in everything that they do. And immediately after yes, the panel discussion that is mentioned, as I want to welcome you once more to our beautiful university, I would like to remind you that it is the only university located in the judicial capital of South Africa, and this is critical for law students who are not only equipped with legal theories, but also with legal practice as the result of our collaboration with the court. With these few words, I want to welcome you once more. Thank you very much.
Thank you very much, Prof. Kamga. I would like to proceed to call forward Prof. Francis Peterson, Vice Chancellor and Principal of the University of the Free State, for an official opening for the day's events.
Thank you very much, Annalie, Program Director. And distinguished guests, good morning. As the Dean has said, I'll follow protocol, and I'll accept that the introductions that were made to our prestigious guests this morning, I also fully support that, and welcome to all of you. It is indeed a great privilege for me, in my capacity as Vice-Chancellor and Principal of the University of the Free State, to open these proceedings and to formally welcome you all. Now, as the Dean has indicated, March is one of the most significant months on the South African calendar. It is almost unthinkable that less than 3 decades ago, South Africa did not have a Bill of Rights, leaving large portions of our society vulnerable to discrimination, abuse, and injustice. And Nelson Mandela famously said, to deny people their human rights is to challenge their very humanity. And for many years, the humanity of so many South Africans was challenged in an incomprehensible way. The fact that we have one of the most modern and progressive constitutions in the world today, with a comprehensive Bill of Rights firmly enshrined in it, is largely due to the efforts and sacrifices of people like Emeritus Justice Albie Sachs and Sir Sidney Kentridge. And I also want to add here Justice Zak Yaqub and others. The fact that the Dean have said that there are different scholars that's doing actual work and have diverse views on the Bill of Rights, we probably will hear some of those views and perspectives in the panel discussion, but that doesn't mean that we haven't got a comprehensive Bill of Rights. We truly stand on the shoulders of giants who had the courage to speak out and stand up against injustice at a time when it was largely deemed unpopular and certainly dangerous to do so. The University of the Free State honors you for your invaluable contributions towards establishing a South Africa where the rights and the dignity of all our citizens are honored and upheld, and the very humanity of every person can be respected. In the context of higher education and the higher education sector in our country, the value of human rights can never be overstated. The pursuit of knowledge can never take place without the pursuit of justice and equality happening in tandem with it. For universities, it remains critical that every aspect of academic life, from right when our student starts to enter the university through admissions, and the curriculum, to campus culture and governance, is viewed through the lens of human rights. At the center of our purpose and our operations as a university lies the principle of equality. After all, every individual, regardless of race, gender, religion, or background, has the right not only to access higher education, but in fact to succeed in higher education, enabling them to reach their full potential. And it is our duty as educators to create an inclusive environment where all of our students feel welcome, accepted, and valued. Part of that duty is to put systems and structures in place to ensure student success. And I'm proud to say that in this regard, the University of the Free State is playing a leading role in South Africa with our innovative and very active, effective student support initiatives. And it in fact goes quite a long way that the work that we are doing in that space is not only leading those practices in understanding of student success in South Africa, but is also playing a pivotal role in the United States of America and also India. It is to a great extent due to these initiatives that we have been able to consistently achieve amongst the highest institutional success rates in the country. But although the issue of access to higher education has been largely addressed, and great strides have been made towards ensuring that the success of our students, there are still remaining a significant challenge, and that's the challenge towards human rights on our South African campuses. Among these challenges are gender-based violence and also stark socio-economic inequalities that still remain and still exist. It remains essential that we address these through a culture of care and support, and by creating an environment of openness and engagement on our campuses. And we often say that is what universities are all about. It's an opportunity to operate in safe spaces and engage with one another in diverse views and on diverse views without having the threat of those safe spaces or platforms being closed down. Intertwined with human rights, of course, is the principle of social justice. The one is in essence a logical outflow of the other. Where human rights refer to the innate rights and privileges that come with being a person, social justice points to the fair and the just interactions between individual and society. As an institution of higher learning, the University of the Free State takes its responsibility towards furthering social justice extremely seriously. So seriously that we, in fact, have entrenched it in our mission statement. And that mission statement talks to the University of the Free State being a research-led, a student-centered, a regionally engaged university that contributes to development and social justice through the production of globally competitive graduates and knowledge. In the pursuit of social justice, we seek to advance the values of human dignity through ethical and transparent institutional responsiveness. In our South African context, we believe the principle of social justice entails an emphasis on inclusivity, reducing inequality, and creating opportunities and pathways out of poverty and dispossession. And these opportunities and pathways can only be created through education. Our educational role as universities remains not only to create capable workers for the job market, but really to cultivate good, responsible, ethical leaders with a deep respect for rights and dignity of others, who can take our country and our region, and indeed our world forward. Earlier this morning, I had a meeting with an entity, with the CEO of an entity called Social Innovation Exchange. And we were talking about global leadership and the vacuum that we've got there currently. And it's important to remind ourselves as universities to what extent do we fill that vacuum? To what extent do we create leaders that actually could fill that vacuum? And to what extent do we help shaping the views of where our multipolar world is going to? So social justice also occupies a prominent position in our Vision 130, which encapsulates our intent to renew and to reimagine our institution for 2034 when we celebrate our 130th birthday. By acknowledging it as one of our core values, we want to ensure that our future institutional decision-making and processes are guided by this important principle. And along with social justice are the values that is part of our vision of innovation and impact, values of accountability, of care, and also of sustainability. One of the ways this core values of ours finds expression is through the work of the Free State Centre for Human Rights. And Annelie is at the moment acting in that centre in the absence of Professor Dani Brandt, that is an acting judge at the High Court for a period up in Pretoria. The centre is not only a hub for human rights studies, as it brings together multidisciplinary academics, activists, and practitioners. It is also committed to research, to advocacy work, and the provision of legal services, and specifically to those communities which can't afford legal services. Over the years, it has played a sterling role in bringing social justice to communities across our country, and has been a champion in upholding and furthering the principles of human rights, of fairness, and of equality. To our two benefactors, a heartfelt thank you for your generous donation to our institution. And as the Dean has indicated earlier, Vanessa will be talking about that and the whole process that's on my left a little bit later in the program. But once again, also thank you in advance for being here, Vanessa and Albie, and for the wonderful donation that you will do later on. So colleagues, delegates, may today's proceedings bear testimony to the University of the Free State's solid commitment towards the furtherance of human rights on all of our campuses, in our surrounding communities, and as a responsible global citizen, also towards expanding a human rights culture beyond our national borders. And may you leave here assured of the fact that your contributions will be used to further this goal. And I'm also grateful for some of the students, and hopefully there will be more students that will be joining us a little bit later, of being present here, because that in itself is a good learning experience, get ideas of people that have done major, fantastic, memorable contribution to this country, but also on the continent and the globe. Thank you.
Thank you very much, Prof. Peterson. And thank you also for outlining the context for why an event like today is not only informative, but also it is indeed a celebration of how far we have come as a country. We now move into the panel discussion for the day on the contribution of Sir Sidney Kentridge to human rights in South Africa and beyond. The facilitator for the panel is Prof. Elsevier Skuman. Prof. Skuman is the Dean of the Faculty of Law at the University of Pretoria and a former Deputy Dean of the Law School at the University of Auckland. Her areas of specialization are private international law, conflict of laws, and comparative law. She has published widely in these areas and has also made contributions to international legal encyclopedias as well as submissions to law commissions. She has advised law firms in South Africa, New Zealand, Australia, the United Kingdom, the United States, and Germany on transnational commercial litigation. She holds an Alexander von Humboldt Fellowship and regular research at the Institute for Private International Law in Cologne and the Max Planck Institute in Hamburg, Germany. She is an elected associate member of the International Academy of Comparative Law, as well as a full member and judge of the Expert Committee of the St. Petersburg Institutional Legal Forum. Please join me in welcoming Prof. Skuman. I can then also maybe ask that the panel members can also come forward and take their seats. Thank you very much.
Good morning, everybody. It is a real pleasure indeed to be in Bloemfontein today. Thank you very much to the Dean of Law, Professor Serge Kamga, for your very kind welcome, and also for inviting me to be part of this program. You know, the Deans stand together, also in human rights. Thank you also, Dr. Annelie de Man, for the very generous introduction and also for your moderation of the program today. As I said, it is a real pleasure for me to be here in Bloemfontein. I've got a very special bond with this city. This is where I spent my secondary school education years. And so it's always good to come back to beautiful Bloemfontein, even though it seems to be stuck in a heat wave. I would also like to thank our guests, our hosts, who have really been very generous in receiving us in Bloemfontein yesterday. Thank you very much, Professor Kamga, to you and your team, as well as the VC, Professor Peterson. We are really honored and privileged to be part of this. Then to the panel, who have joined me here on stage. I don't think they need any introduction, but I will introduce them as they come up to do their presentations. So the session will work as follows. I will introduce each panel member. They will do a brief presentation, and after the presentations, I will open up the floor for questions and answers, or should I say responses. One might not have exact answers to everything, but questions and responses. So as you know, today we are celebrating the career and achievements of Sir Sidney Kentridge, who is 101 years old, and we are looking at his role in human rights. I'm very humbled to be in the presence of some of the greatest human rights scholars and judges, not only in this country, but on the continent and in the world today. So I don't have any doubt that we will do Sir Kentridge justice today. Just a very brief introduction. Sir Sidney Kentridge was initially a member of the Johannesburg Bar. His highly successful general practice included several significant political matters: inter alia, the Sharpeville Inquiry, the treason trial, the Steve Biko inquest, to name but a few. He later moved to practice in London. A long-time member of Brick Court Chambers, he was appointed Queen's Counsel in 1984 and a bencher of Lincoln's Inn in 1985, retiring from full-time practice in 2013. He was knighted in 1999 for his international human rights work. He has sat as a judge of appeal in Botswana, as a judge of the Courts of Appeal of Jersey and Guernsey, and as an acting justice of South Africa's Constitutional Court. He retired at the age of 90, precisely 64 years to the day after he had first been called to the Johannesburg Bar. On occasion, Jeremy Gauntlet, SC, has said of Sir Kentridge, he has the natural gift of a deep baritone voice and the acquired ones of a deliberate fluency and perfect timing in delivery. He was unrelenting. In court, he spoke in carefully constructed sentences, often whole paragraphs. His manner was cool and ironic, cold and with a slashing sarcasm when angry. He was very well read, and his humor was dry. I want to mention too that I'm delighted to see so many students here today. I'm a very firm believer in intergenerationality, and for me it's always good to see the mix, you know, the younger ones and then the older ones, and I'm counting myself amongst the older ones now, although I'm not an elder yet. So I want to extend a special word of welcome to the students today. I don't know if you are bunking class at the moment, but I'm sure your dean will excuse you for that today. So without further ado, I would like to call the panelists to the podium now. I'm going to start with retired Justice Zak Yacoub. If you will just remain seated for a moment, please, Judge. Justice Yacoub took silk in 1991 and practiced as senior counsel until his appointment as a Justice of the Constitutional Court in 1998. In service as Judge of the Constitutional Court of South Africa from 1998 to 2013, he became known nationally and internationally for his contribution to the socio-economic rights jurisprudence of South Africa. After his retirement, he received the 2013 Felicia and Sidney Kentridge Award for Service to the Law in Southern Africa and was awarded 5 honorary doctorates from the universities of Fort Hare, KwaZulu-Natal, Witwatersrand, Pretoria, and the Free State. Both before and after retirement as a judge, he has taught at law schools in Seattle, Melbourne, India, Maryland, and also taught constitutional law at Witwatersrand and in the joint program between the Howard Law School, Washington, and the University of the Western Cape. Ladies and gentlemen, it is now my pleasure to invite Justice Yacoub to the podium.
Good morning, everybody. It really is an absolute pleasure to be here. In the interest of equality, I do not go through protocol, nor do I mention anybody in particular, except, of course, for those who are here who have the responsibility of carrying human rights into the next generation. And those are all the students who are here. They are the most important of us, because it is not what human rights are like today. It is how and whether we convey them and move them in to the new generation. So students, come on, let's see how many of you there are here. Give yourselves a hand. Well, that is wonderful, and I think I take that as a promise that you will all contribute fiercely towards the achievement of human rights in our country in the future, and you will usher in not the kind of human rights that we've been talking about, but a new era in human rights, because it is your minds that we rely on, your creativity that we rely on. We have become old and slow nowadays, and we depend on you to get it right. And now let us talk about Sidney Kentridge. What a wonderful man. And I want to start by talking about a time when I was his junior. And the point of his story is to show that human rights is not only about talking, not only about writing judgments, it is about the practice of human rights. So when I was a junior in a case which involved the death penalty in a political matter, it's a very serious issue because the person wasn't found guilty of murder at all, but he was found guilty of of contravening the provisions of the infamous Terrorism Act in those days, and he was sentenced to death for those activities because he had thrown a bomb somewhere, despite the fact that nobody had died in consequence of this. This would have been an absolutely impossible appeal to handle. And I know that my attorney found it very difficult to get a senior advocate to manage a case like this in the early 1980s. It was shortly before or at around the time he went over to London. So I called him because I was his junior, and I was surprised, having arranged transport to get to his chambers, that when I got to the airport, Sidney Kentridge was himself there to fetch me. I was shocked and wondered what was happening. And he said that he had called my chambers and cancelled my transport. He thought he should pick me up himself. He picked me up himself, took me to his chambers. We worked together. He dropped me back at the airport, made sure that I was properly looked after by the airport people before he himself went home. So that was the practice of human rights. You see, disability doesn't mean that you don't have to help people. Poverty doesn't mean that you don't have to help people to feel better and get better. You've got to do more, but helping people is a very important part of it. And Sidney practiced that, and I admired him for that a great deal. It was an amazing experience. But he was also a hard and difficult taskmaster. I wrote the heads of argument for this appeal, and it had two sections. It had a principled approach, and the second half dealt with the facts. And of course, he changed the principled approach so much that it was utterly unrecognizable. When it came to the facts, he left that section completely alone. And I patted myself on the back thinking, hey, man, I must have done a very good job of this, because he didn't touch that section at all. He argued the principled section brilliantly. And one of the questions asked of him is, Mr. Kentridge, what if people had died as a result of the fact that that bomb had been thrown? And Kentridge's answer was simple. He said, then they would have been convicted of murder, my lords. And that would have been a very, very different kettle of fish. And that was the end of that. And then he delivered the argument on the principles. And when it came to the facts, he said, the facts are all there. Your lordships can read them. My junior had done a very good job on them, and I will not bother with them at all. So he did not touch the facts at all when he argued the case. Of course, I must talk about the Biko inquest a little bit, because I remember one part of that very, very well. So somebody, the person in charge of the commission, the inquest, said to Sidney Kentridge, somewhat condescendingly, that, well, you may speak English if you have difficulty with Afrikaans. And he said, I speak Afrikaans very well. I have no difficulty to speak Afrikaans, but I choose to speak English. And that is what set the scene for the whole thing. The security branch people and so on were well cross-examined. And then the next part of my acquaintance with him was when he assisted the team in the Delmas trial. We had a very difficult moment in that Delmas trial. The Delmas trial was where a large number of people were charged with treason. And I was part of the legal team, and Arthur Chaskelson and George Bezos were the leaders of that team, all very famous people. I was a little junior part of it then. But what had happened was that an assessor in the case had signed a UDF campaign, which was a multi-million signature campaign, because he believed in democracy and what a broad UDF was supposed to achieve. And ultimately, Van Dijkhoorst, who was the judge in that case, fired the assessor because he had signed. Now, if he fired the assessor wrongly, it means that the court was wrongly constituted. And then we discussed the matter with Kentridge. After that, Kentridge was brought in to advise us. So he was, you've heard the term in relation to him, that he was the barrister of barristers. Arthur Chaskelson, George Bezos asked Kentridge to come in and talk to all of us about how to prepare this very, very complicated case in relation to the recusal of judges. And that was indeed a very important eye-opener to me, because I didn't understand it. But he said, well, you will have to argue for the assessor to be brought back into the case. But you will have to do it on the basis of the hope that he makes a mistake of not bringing the assessor back into the case. And I did not understand this very well at the time. And of course, we failed in our duty to bring, in our application to get the assessor back into the case. And when the case went on appeal, the basis on which we won the appeal in the Supreme Court of Appeal made the point that Kentridge had made, that it will be a good thing if you lose this application to get the assessor back. Because what the appellate division said was, well, the trouble is that the assessor should never have been dismissed. The court was badly constituted after the assessor was dismissed. There's no reason for a retrial, and all the accused are found not guilty and discharged. It was simply on a very interesting point that Kentridge himself made, which I didn't understand at the time. And then comes his participation to the Constitutional Court when the Constitutional Court started. That was very interesting because none of us at the time, and none of the judges who had been appointed to the Constitutional Court had any real experience in constitutional law. We had a theoretical idea of what constitutional law was all about. We had read a great deal about it. We had read many cases about them. But as far as any real experience in the execution of constitutional law, none of us knew too much, I have to confess. And it was a godsend almost that when the Constitutional Court started, and I wasn't there, one of the judges, Richard Goldstone, had taken leave from the Constitutional Court to be a prosecutor in a very, very important international commission. And when he was away, Arthur arranged for Sidney Kentridge to leave London and to come to South Africa for 9 months, for between 6 and 9 months, to be part of the first bench of the Constitutional Court judge as an acting judge. And the contribution he made, the contribution he made was absolutely amazing. He wrote, Sir Sidney Kentridge, the first judgment ever delivered by that court in April 1995. There are many cases argued in February 1995, including the death penalty and one or two others. But the first judgment that was actually delivered was in April 1995 in the case of the state versus Zuma and two others. And no, it wasn't that Zuma, everybody. It was a completely different Zuma, this one. It was not J.G. Zuma. This was a guy who, in conjunction with two accused, had been found guilty of murder. And the whole issue was whether he had got a fair trial. So firstly, it was the first judgment that was ever published of the Constitutional Court. Secondly, it was the first time in the history of this country that legislation was set aside because it was found to be inconsistent with the Constitution. And what is important is that it dealt with a very unpopular area. It dealt with an area of criminal law. It dealt with an area of fair trial. And it took a lot of courage to develop that because, you see, at that time, many people in our country were thinking, and they still think, that somehow if you're too lenient to an accused person, it's a very bad thing because you encourage crime and so on and so on. And the principle of being innocent until proven guilty and giving people a fair trial was not well understood. And he wrote this first judgment in which a provision which transferred the onus, I mean, all of you understand that, let me explain the onus quickly for those who don't understand the law. In any case that you bring, there's an onus. Because what happens is that when evidence is led on both sides, and the court doesn't know who to believe, this side or that side, and that very often happens, because everybody gives evidence very nicely, some people are well tutored, and it's difficult to work out who's speaking the truth and who's not, because, you know, judges are not God after all. And so what happened was that there's an onus. The onus provision is that normally in a civil case, the case must be proved on a balance of probabilities. In a criminal case, the case must be proved beyond a reasonable doubt. But here there was this provision in a South African law which said that if a confession is made by an accused person to a magistrate, the onus is on the accused to show that the statement was not freely and voluntarily made. The problem was that the accused had to prove a negative, but the other problem was that the onus is on him, which means that if the court doesn't know who to believe, it means that the accused gets convicted. That, Kentridge found, was not fair. It was not fair. The onus could not stay there. It had to change. And he talked about the vulnerability of accused people. He talked about the dignity of accused people, something which is very, very unpopular. He talked about how accused people face imprisonment, the importance of the onus, and he dealt with the public argument and the public perception in great detail. But more important than that, he laid down the law in many other ways which was relied on by the courts later. You know, we regard it, and all law students would know that we must start with a generous interpretation of the Constitution. That generous interpretation was brought about by that first judgment by Kentridge, which everyone now relies on. That was the first Constitutional Court judgment that spoke of a purposive interpretation or a purposive construction. And it was the first Constitutional Court judgment which spoke about the fact that a general construction, a purposive construction, which we rely on again and again, but more importantly, it was the first judgment that brought in the issue of dignity, human dignity, and its importance. Because although our Constitution had the right to the interim Constitution had the right to human dignity in it, our justification clause, and I'm sorry if I take a bit of time to just explain it, is the limitations clause which says that you can limit a right in certain circumstances. And in terms of the interim constitution, the rights could be limited, but only in a way which is consistent with a society based on freedom and equality. So freedom and equality were the only two founding values of the Constitution, in a way, which were taken into account to decide whether the rights should be limited or not. So the death penalty judgment learned from the first Kentridge judgment and brought in the issue of dignity. And I want to add that we were on the Constitutional Assembly at the time, and when we drafted the Constitution, what happened was the final Constitution, we took into account Kentridge's judgment, we took into account the death penalty judgment, which was the result of Kentridge's judgment, and precisely because of Kentridge's judgment, we included in the drafting process the concept of human dignity in Section 36 of the Constitution. So now we have to look at a society based on dignity, equality, and freedom. And dignity was not only introduced, but it was the first one there. So that was extremely important, and he was responsible for changing the Constitution. I have a lot more to say, but I should stop now and add that the value of Sidney Kentridge, Sir Sidney Kentridge, is not that we revere him all the time. We only value him properly by doing our best to make our contribution towards the achievement of human rights. Thank you very much.
Thank you very much, Justice Yaqub, for that very personal experience that you related and shared with us with Sir Kentridge. Everybody starts at the bottom, and then you must make sure that you rise to the top. I'm sure that was an experience that you will never forget, and we will also treasure that. Today, you are truly at the top, and I think for the students here present today, it is a great experience to hear directly from the horse's mouth, so to speak, from Justice Yaqub. Thank you very much for your contribution, and I'm sure there will be many questions from the law students later on. Thank you very much. It is now my pleasure to introduce Justice Yvonne Thokozile Mbatha. I just met her for the first time this morning, and it is a real pleasure. It really makes my trip here worthwhile to Bloemfontein. And it is a pleasure to introduce you as our next speaker. Just very briefly, Justice Mbatha is a South African judge of the Supreme Court of Appeal. Before her appointment to the Supreme Court of Appeal in 2019, she was a judge of the KwaZulu-Natal High Court from June 2011 to June 2019. She acted in the Constitutional Court between August and December 2022. Justice Mbata, welcome to this celebration today, this event today, celebrating Sir Sidney Kentridge, and we are looking forward to hear a little bit more about him from you as well. The floor is yours.
Thank you, Madam Program Director, and good morning to you all protocol observed. It is a great honor for me to have been invited to this auspicious occasion amongst all the greatest jurists that are present, and I'm being one of the most junior ones, but I'm really humbled to be part of this occasion. My colleague, Zach, has discussed the judgment of Zuma, which was the first judgment of the Constitutional Court, and of course, which was penned by Sir Sidney Kentridge. I will not repeat what he has said, but I would like to highlight what I found to be the most important principles that I learned from that judgment, and which are important for the rule of law and for interpretation, and which are important to everyone who is present here. The Zuma judgment gave important guidelines with regard to constitutional interpretation. It emphasized that the sovereignty of the Constitution and no longer sovereignty of Parliament, and that the absolute rules of statutory interpretation are not suitable for interpreting the Constitution. Important principles which are in line with the Constitution should apply when one interprets the Constitution, as it is a value-based Constitution. The Constitution should be promoted in a way that should promote the values of the Constitution. International human rights law and comparable foreign law should be applied when interpreting the Constitution. As my brother Zach has said, that a generous rather than a legalistic interpretation should be given, because the Constitution deals with value-based matters. That's the only part of the Zuma judgment that I would like to emphasize or share with you. Then I also had the privilege of reading the judgment of Mhlungu and 4 others. Mhlungu and 4 others were had almost simultaneously with the Zuma judgment, because it raised initially, firstly, the issue of Section 2171B, which dealt with the presumption which my brother Zach has alluded to. And then, but it raised a separate question, that is the proper construction of Section 2418 of the Constitution, which did not arise in the Zuma judgment. Section 2418 briefly stated that all proceedings which immediately before the commencement of this Constitution were pending before any court of law, including any tribunal, shall be dealt with as if this Constitution had not been passed, provided that if an appeal in such proceedings is noted or review proceedings with regard thereto are instituted, after such commencement, such proceedings shall be brought before the court having jurisdiction under the Constitution. So the conundrum here was what is meant, or what should be interpreted to be meant by pending. This judgment had came from my court, KwaZulu Natal, just like the Zuma judgment, but this one was penned by Justice Page. The question before the Constitutional Court was that, were the proceedings before Justice Page pending, or to be considered to be pending, immediately before the commencement of the Constitution? And if so, whether on the proper construction of Section 2418, it rendered the Constitution inapplicable to those proceedings. We all know that criminal proceedings commence with the serving of the indictment and the lodging thereof with the registrar. So when this case was debated, there were quite a number of views. Kentridge wrote a separate judgment, but the majority judgment came to this finding: that the Constitutional Court sought a fair trial for all persons. As a result, a purposive approach should be adopted as opposed to a literal approach. The finding by the majority was completely different to the one that was found by, say Sidney Kentridge. Sidney Kentridge had solely or relied on the literal interpretation. What is important about the Mhlungu judgment? It's what my brother Zak Yakub has just said. It was also about the fairness, the rights to a fair trial. If one needs to get a fair trial, it all depends on how the Constitution should be interpreted. One of the most important, or I would say the most famous judgments, where also Sidney Kentridge participated, was the famous or infamous State versus Makwanyana. Almost every law student knows about Makwanyana, as it ended the death penalty in South Africa. In that case specifically held that decisions, whenever a court should decide on the matter, decisions should be based on sound reasons and the law. The court found that the constitutionality of the death penalty, let me rephrase that. The court held that the death penalty was unconstitutional, and having come to that conclusion, it must be borne in mind that at that stage, there are no precedents that we're dealing with that kind of a situation. Death penalty was mostly prevalent here in South Africa. So it ruled that you have to interpret the cases by recourse to the Constitution, and also to consider international law, and also the context, which it found to be very much important. Consider the purpose also of the instrument, if we are applying the interpretation in terms of the Constitution. And what is most important is that you must come to a just and a fair decision. Consult all the legal resources available, and a court also may exercise a discretion, and that this always involves a subjective state of mind in order to come to a fair decision. So in general, like now with the current Constitution, Section 39 is often applied when one considers the interpretation, which requires you to interpret the law in line with the Constitution and the Bill of Rights. In Makwanyana, the court held that the provisions of the Constitution should not be construed in isolation, but in their context, which includes the history and background of the adoption of the Constitution, together with other provisions of the Constitution itself, and particularly the Bill of Rights. It went on further to say that when interpreting a statute, it may be permissible to take into account debates of Parliament statements by minister responsible for the legislation, reports of judicial commissions of inquiry, the object of the statute, its scope and purpose. It held that because there is no definition of what is to be regarded as cruel, inhumane, or degrading punishment, the court had to give meaning to these words itself. It also took into account international law, which should be used as an instrument of interpretation. It acknowledged that the majority of South Africa were in favor of the death penalty, but stated that public opinion should not sway the court. The judges relied on different sources when they interpreted or when they dealt with the issue of whether the death penalty was a cruel, inhumane, or degrading punishment. Some of the judges applied the principles of Ubuntu, indigenous values, and others used the literal translation. But I would like to highlight what Sidney Kendridge found. Sidney Kendridge found that, I quote, "The imposition of the death penalty was not a question of a right to life, but whether the imposition of the death penalty constituted cruel, inhumane punishment." That is in paragraph 194 of the judgment. He found that the imposition of a death penalty was cruel and inhumane because it infringed on the right to life, dignity, and equality. Albie Sachs, who's with us today, his finding, he agreed that the right to life was unqualified. But did not agree with the reliance placed on the prohibition against cruel and inhumane punishment. I hope I'm quoting him correctly. His approach was based on rationality and proportionality, that the death sentence could not be justified. Though unanimous, the judges' decisions were reached on different constitutional values, rights, different methods of interpretation, different sources for their interpretation. Also in Makwanyana, the court illustrated the various methods of interpretation: the grammatical interpretation, the purposive interpretation, context, which includes background and history of the adoption of the Constitution, and in particular the Bill of Rights, and that meaning should be given to the undefined rights and values of the Constitution, and that discretion also plays a part in important decision-making. But at the same time, it also emphasized that judges are human, and there's no absolute neutrality. So I think that touches on the question when the judge has to exercise a discretion in that matter. But exercise of a discretion should not be influenced by your subjective values or what you think is right and wrong. I've extensively read about Sir Sidney Kendridge. I've read various articles that were penned to honor him. And there's one which really touched me. It's one where the late Chief Justice Chaskalson penned a tribute to him. What he mentioned, he said he seldom raised his voice, but was a deadly cross-examiner. Judges were warned not to give judgment after he had been in court, because they would definitely go with him. Justice Chaskalson also stated that Sir Kendridge advocated for ethical practice. I've seen that also highlighted in one of the tributes to him by a bar council. I think this paper was delivered by him, where he talked about competency from the bar and about how advocates in the past would not choose who they are representing, and they would represent anyone irrespective if that person was infamous or not popular, and that showed quite a lot of high ethics. But most importantly, he stated that he abhorred apartheid to such an extent that he never accepted to be a judge in the apartheid South Africa, but instead served as a judge in Botswana. When one reads about such an eminent jurist, you'd like to emulate him. You look at issues that touches, for instance, I come from the judiciary, that deal issues with judicial independence. Do we espouse to those principles? Do we follow the likes of, say, Sidney Kentridge? Are we the defenders of the Constitution? Are we upholding the Bill of Rights? Are we applying it in our judgments? It has been quite a great honor for me to participate in this, because it has made me to look and think of what I am doing as a sitting judge. I've also considered the principles that apply in the rule of law. I mean, it is very important that the Constitution should be regarded as the supreme law of the Republic, and any conduct that is inconsistent with it should be regarded as invalid. Are judges at the moment upholding the Constitution as the supreme law of the land? That's a question that we need to ask ourselves. And also promote constitutional values, including the rights to human dignity, equality for all, and advancement of human rights. I thank you.
Thank you very much, Justice Mbata. I hope that today you have inspired all the law students here to read cases. I'm quite casuistic in my approach to the law. I spent some time in the common law. And for me, that is the ultimate proof of the law, is how it plays out in cases. But then you have to read every judge's judgment. Correct, Justice Mbata, not just the majority. The real gems may be in the minority. So I really hope that you're all inspired today after the analysis of some of those important cases, that you will really read the cases in detail. Thank you very much, Justice Mbata. We've now heard it straight from the bench. And now we are going to cross over to academia. It is my pleasure to introduce to you Dr. Audrey du Plessis. You might know her. She might be teaching you. Dr. du Plessis is a senior lecturer in the Department of Public Law here at the University of the Free State. She holds a doctoral degree in constitutional law. Her thesis was titled "The Constitutional Framework of Broad-Based Black Economic Empowerment." She has published in accredited journals and presented papers at national and international conferences. She is the chairperson of the University of the Free State General and Human Research Ethics Committee and secretary of the Administrative Justice Association of South Africa Teaching Administrative Law Subcommittee. I hope I got that right. Thank you very much for joining us this morning, and we are looking forward to your presentation. Dr. Audrey du Plessis.
Honourable Judges Sachs, Yacoub, Mbata, Mr. Temba, Professor Peterson in his absence, Kamga, and Skuman, thank you for, and obviously the members of the legal fraternity and the judiciary are here, and the students and other guests. As you heard Justice Yacoub said, the students are the most important part of this event. Thank you for the opportunity of being part of such a prestigious event and to celebrating human rights and to share a panel with such esteemed guests. I'm really humbled. So I was asked to present the work of Sir Sidney Kentridge in his contribution to law from an academic perspective. Let me firstly say that the overall impression I was left with in preparation for this occasion was one of being absolutely inspired by the career of this great man, Sir Sidney Kentridge QC. I believe it to be a feeling that anybody would have reading his work and studying the work of this great legal scholar. So Sir Sidney isn't primarily an academic, although he did spend some time teaching at Harvard Law School in the early 1970s. But I believe that his contribution as judge of our constitutional court, the courts in the Channel Islands and Botswana, his writings, his talks, and his work as advocate and barrister can justifiably be framed as academic contributions in own right. He's widely admired as an exceptional legal practitioner and a courageous defender of the individual against state oppression. On the occasion of Sir Sidney's knighthood, Lord Alexander of Wheedon, QC, referred to him as simply the most highly regarded advocate in the Commonwealth. Illustrative of his remarkable performance in South African legal practice, I should perhaps relate what Sir David Napley wrote about him in his autobiography, Not Without Prejudice. Sir David Napley was a previous president of the English Law Society who came to South Africa as an independent observer of the proceedings at the Biko inquest in 1977. And reflecting on the proceedings, he wrote that, and I'm paraphrasing here, that acting for the police was Retief van Rooyen, SC. He represented his clients with skill and vigor. For the doctors acted Mr. B. de V. Picard, SC, also an advocate in private practice, who represented his clients with neither skill nor vigor. And acting for the Biko family was Sidney Kentridge, a cadaverous, mild-mannered man. He made the others look like pygmies. I have it on good authority that at an administrative law conference in Cambridge, attended by both the Chief Justices of the US and the UK, the Chief Justice of England was overheard saying to his US counterpart, "Oh, look, there's Sidney Kentridge. He's simply the best advocate in the world." The other side of his advocacy was the acerbic bravery he displayed in the face of fiercely pro-apartheid judges. Former Deputy Chief Justice Dikgang Moseneke specifically names Kentridge as one of those advocates who raised his voice against the injustice of apartheid and accepted briefs that attracted the displeasure of the ruling elite, the exception rather than the norm. I will not elaborate on all the high-profile cases he was involved in, like the treason trial between 1958 and 1961, the Sharpeville inquiry in 1960, his defense of Bram Fischer in 1965, the Winnie Mandela trials between 1970 and 1986, and obviously the Biko inquest in 1977. But these are some of the most prominent cases from the apartheid era. Suffice it to say that from his writing and from his advocacy, it is clear that he believes strongly in human rights and the rule of law. Sir Sidney is a legal polymath who's a distinguished practitioner in a variety of fields: commercial law, insurance law, constitutional law, in both England and South Africa. He acted as counsel in cases in the European Court of Human Rights in Strasbourg and was knighted in 1999 for services to international law and justice. But being a constitutional law scholar, I believe that his most significant contribution is in the field of constitutional law, human rights law, and administrative law as far as he used it to fight the vast security apparatus of the apartheid regime. So I want to touch on his contribution in constitutional law and human rights law. He played a role propelling South Africa towards a Bill of Rights. Delivering the John Foster Lecture at the University College of London in November 1986, Kentridge offers a less bleak outlook than he had on previous occasions. His forecast was for a peaceful transfer of power in South Africa and agreement on an entrenched constitutional Bill of Rights. It was prescient in content, if not in timing. I only saw it happening at the turn of the century. Fortunately, it happened a bit earlier. His ideas for the civil rights he foresaw in this Bill of Rights. He said, and I quote, "Most of us would, without precise definition, accept as fundamental rights. The rights not to be unlawfully detained, the right against inhuman treatment, the right against discrimination based on color or race, freedom of movement, freedom of speech, private property, and representative government." My impression from his writings is that he thinks deeply about the death penalty and issues such as the right to a fair trial. My own thoughts, perhaps misplaced, was that he was deeply influenced by his very first case as a young advocate, which he lost, and his client was subsequently sentenced to death. But it brings me to his time on the Constitutional Court, where I want to highlight two specific cases that dealt with these issues. He acted for 2 terms and turned down an offer of a full appointment. But like the honorable 2 guests before me said, that he delivered the Constitutional Court's very first judgment in State versus Zuma. Now, I'm not going to delve into the details of State versus Zuma. You've had it on much better authority than what I could possibly give. But what I want to focus on is the treatment of the limitation clause that he propounded in that judgment. The first thing is that the court considered the reason for introducing this reverse onus provision versus the potentially grave impact of the accused on the accused of being convicted over the reasonable doubt of a court. The state's burden was said to be not impossible or unduly burdensome, and it was found deserving, but that it overlooked the interests of the accused. Therefore, a proportionality analysis between the pressing social need for the effective prosecution of crime and the interests of the affected individual. And then one of the court's monumental judgments came during this period, namely State versus Makwanyane. Everyone is familiar with the details of this case, which dealt with the constitutionality of the death penalty. The court carefully analyzed the 3 relevant rights in the Bill of Rights and then proceeded to a limitation analysis in terms of Section 33 of the interim constitution, now Section 36 of our constitution. But both in State versus Makwanyane and State versus Zuma, Sir Kentridge contributed to the interpretation of our limitation clause in form and in substance. In State versus Zuma, he propounds the 2-stage approach to the interpretation of the limitation clause, similar to the Canadian Supreme Court's approach. He helped introduce a framework for interpreting the constitutionality of limitations and establishing the proportionality principle in our constitutional law. In State versus Makwanyane, he offered 2 possible approaches to the limitation analysis. First was to consider it subjectively from the viewpoint of the impact of the action on the individual concerned, which he found wanting. He supported what is sometimes called the objective approach, where the more appropriate method would be to examine the law which is said to be justified. To Kentridge, the key is the phrase law of general application, repeated in section 36 of the Constitution. In other words, the law itself, and not necessarily the impact on the specific individual, should first pass the test. He carefully explained how a limitation of an individual's right, for example, the negation of the right of freedom of movement of a specific prisoner, does not negate the essential content of the right. The generality of rights included in the Constitution is upheld if the law preserves the right for most people at most times. In other words, the public interest plays a central role. However, it is also critical to, in this analysis is the concept of proportionality. A few years later, and I believe taking with him his judgments from our South African Constitutional Court, he developed his reasoning with reference to a Privy Council case of Brown versus Procurator Fiscal, which concerned the right not to be compelled to incriminate oneself, a critical part of the right to a fair trial. The Privy Council held that the right not to incriminate oneself is a fundamental part, and it's not unqualified, and that the court's task was to find a fair balance between the rights of the individual and the general interests of the community in the successful prosecution of crime. The statutory inroads into the rights of the accused was proportionate in the sense that it was not unduly prejudicial or oppressive. I note this specific case as part of my discussion because it reversed the position previously taken by the Privy Council, where Sir Sidney was part of the losing council. So in the Brown case, Lord Bingham said that a limited qualification of rights is permissible if directed toward a proper public objective and if the qualification of the right is no greater than the situation calls for. A balance had to be struck between the general interests of the community and the personal rights of the individual in a manner not unduly prejudicial to the individual. So this approach shows the importance of careful consideration and analysis of the context and the law. Speaking of what he saw as the proper way to approach limitations, he said that the approach he hoped for would be that the authority seeking to justify limitation of a fundamental right carries a heavy burden of persuasion. With reference to the phrase necessary in a democratic South African society, also repeated in our section 36 of the Constitution, he argues that necessity does not reach the level of requiring the objective to be indispensable, but that it connotes a pressing social need. When this need is established, then proportionality and balancing becomes relevant. Sir Sidney purports that this method or framework of determining the constitutionality of a limitation of a right is critical, and that courts should avoid approaching the issue in a more pliable manner. In his words, flexibility is no substitute for analysis. In conclusion, and there is much more to say about his brilliance as an advocate, a barrister, a judge, and his contribution to constitutional law and human rights law. And as I mentioned earlier, he was also an accomplished commercial lawyer and criminal lawyer, and undoubtedly he contributed greatly to those areas. But he had something more than this brilliance. He had moral stature. He had courage. He showed bravery in the face of challenges. He had absolute professional integrity, courtesy, and intellectual rigor. In the words of Lord Jonathan Sumption, his great friend, he has something that no amount of forensic technique can impersonate. I thank you.
Thank Thank you very much for that analysis. I think we covered not everything about Sir Sidney Kentridge, but we were able to have a very personal encounter or an account of someone that actually worked with him from Justice Jacob. And then we had the analysis from the bench, from Judge Mbata. And now we had the analysis from an academic perspective, constitutional law. Thank you very much for that contribution. I saw students in the audience taking notes. So I'm hoping that, your analysis will find its way into some of the answers in the exams, or at least inspire some critical thinking about what you said. Also emphasizing that Sir Sidney Kentridge was, of course, not only a human rights lawyer, but a very accomplished commercial lawyer as well. And he had performed his trade in all the top tribunals in the world. So thank you very much for that contribution. Audience, ladies and gentlemen, we are now opening the floor for questions and answers. I'm going to take my seat again. There will be a mic. There will also be a mic that will go around the audience. And please, I think we have about 15 minutes for questions and answers. Please, you have the experts here. Don't let that go to waste. You don't find many opportunities like these. And so I would like you to, when you have a question, please put up your hand. Also, when the mic reaches you, to identify yourself briefly and then ask your question. I'm going to ask the panelists to volunteer in terms of responding to the question. If there is no obvious volunteer, then I will have to appoint someone. But I hope that won't be necessary, that we will have an appropriate panelist to respond to each question. So please put up your hand if you have a question, or maybe a comment or something that you would like one of the panelists to elaborate on. Oh, I see there's our first hand.
Hello, okay. Good day, everyone. I must say it is an honor to be here as a student and to sit in on your hearing. I have a question based on my observation that the Sustainable Development Goals are set there, and former Justice Zach Jacob spoke about dignity being added as one of the first things that changed the Constitution, which suggests to us as the audience of how important it is. And he also spoke about how human rights are not just about studying the rights and just them simply being theoretical. And so that leads to my question about how does human rights scholars, academia, advocates practically ensure that human rights are upheld and protected, particularly in townships and slum areas, seeing that the government has not done much to uphold these rights of these people living there, especially after 30 years of democracy. And so that also highlights how 90% of these sustainable development goals even presented are violated for these individuals. So do South African citizens then need to wait until they go to court to have their rights upheld? So yeah, that's my question.
Thank you very much. Justice Jacob, can I direct that one to you?
Thank you. It's a very, very important question, because people need to empower themselves, and we need to make sure that we manage to develop people in a way where they begin to understand their own human rights. They begin to understand what their rights are. And the idea of organizing and mobilizing, which we used in the struggle for democracy, still remains. And I think that all students and everybody else needs to go to communities to inform people and to educate them in relation to what their rights are, so that they become empowered, they learn to know what their rights are. Not in the sense of teaching them, but in the sense of working together with them. Because as you talk to other people about human rights, however poor they may be, however uneducated they may be, their responses will teach you so much that you will understand a great deal more about human rights. So we've got to start an organization and a mobilization campaign and an education campaign in terms of which we as human beings begin to respect each other's human rights, begin to respect the rights of poor people, begin to respect the rights of women, begin to respect the rights of people with disability, because the more important aspect is not the money government spends on doing it. The most important aspect is a community process which we can start to ensure that people learn. And I must emphasize that it's a long process. People learn slowly. It cannot be done in a day. And all I can say is that if we can improve, in a sense, the awareness of human rights and the empowerment of people in the rural areas by like 1 or 2% every year, we'll get there in 50 years or 100 years. There is no shortcut. We've got to carry on with a very, very long endeavor. Things are much better than they were some years ago, but we have a lot of work to do, and putting our shoulders to the wheel is the only route to go. Thanks.
Would you like to add something?
Thank you. I would like to add something. You do not have to access courts only. I've realized that the Chapter 9 institutions are underutilized. We've got the Human Rights Commission, the Public Protector. So there are various venues where, you can have your access to justice.
Thank you. Thank you very much. I see there is another hand. Please, sir, you may go ahead.
Thank you so much for this opportunity. My name is Bushamini. I am a law student here at UFS. I just wanted to ask, in terms of SV Makwanyana, don't you think that the lack of consideration of public opinion undermines the strength of the Constitutional Court by not aligning with the values of the people in a very young and struggling democracy with populist and borderline undemocratic groupings being founded by everyone from former presidents to common criminals? Wouldn't the court benefit from aligning itself to those values that bind most South Africans, and at the same time bring the court and therefore the judiciary closer to the people, which is an issue on its own? Thank you.
Thank you very much. I'm going to direct that to you. Can you just briefly state your question, please, again? Justice Mbata just wants to get the crux of it, how to align the law with the expectations of the people.
Right. To align, so my question is based on SV Makwanyana and how, I think it was former Chief Justice Chaskauskin who said that ours is not to take into consideration public opinion. So wouldn't the court benefit from aligning itself more with public opinion in terms of buy-in from the people?
Yeah, thank you.
Thanks.
That's a very important question. But when you sit as a court, your first port of call is the Constitution and the rule of law. You shouldn't take into account public opinion, because those people are not versed with the facts and the legal principles that are applicable to that particular matter. That is very, very much important, because if you go only with what the public is saying, the public will always comment about judgments and how they feel, particularly in this case about death penalty because of crime and so on. But when you sit as a court, you need to distance yourself from that, but base your judgment on the values of the Constitution, the facts before you, and the law and how you interpret the law. Thank you.
Thank you very much. Just to add something, of course, public opinion must be taken into account. But public opinion is not decisive, because public opinion is very often racist, is very often sexist, and is very often complicated. So the Constitutional Court, for example, has ruled that we must not be, that gay and lesbian people should be able to get married to each other. Yet there is a large sector of public opinion which believes that gay and lesbian people live in sin. Now, do we live by the principles of equality or not? And the point about it is, do we change our society if we truly, if we accept that today's society is wonderful and fantastic, we leave it as it is. If there's a problem with it, we need to change it. And as far as I am concerned, I believe in the values of the Constitution to the extent where if there is a difference between public opinion and the values of the Constitution, I would go by the values of the Constitution. And I'd go back to my whole point about education. We have got to educate and educate and educate so that the human rights values accepted by our people and enjoyed by our people are in line with those of the Constitution. We have to commit ourselves to societal development, and that point comes in once again.
Thank you very much. Would you also like to add something?
I would just like to add that one should remember that Statement Makwanyane, it was very clear that there was no evidence presented that the death penalty would act as to dissuade or prevent further crime. There's no such evidence in the world. And the court very carefully analyzed the consequences of potentially making a mistake. And it's been worldwide acknowledged that there are mistakes made. But the thing about public opinion, it's also driven by the media and social media these days. And that does not necessarily bear objectivity. There's a lot of a subjective aspect there, so it's dangerous to simply rely on the public opinion driven by this media with its own agenda when you consider a matter before court. Not that I've ever had to, but I just think it bears to be said that the media has got its own agenda, and it shouldn't be the persuasive factor. Thank you.
Thank you. May I also add something as the moderator? I think it's very important to acknowledge the importance of diversity on the bench. Not that judges decide according to their own personal opinions, but I think that diversity is very important. And then also, we heard this morning that social justice is one of the values enshrined at this university. And so there's also a duty on you as law students when you graduate and when you move into society out there, that you advance social justice, that you also take it upon you to effect change where change is required. So I also want to, throw it back to you that there is also an obligation on you when you graduate to remember that you have to advance social justice. Do we have another hand? Thank you very much. Thank you, sir. Please go ahead.
Greetings to the House at large. It is a great honor. So my question is based on international human rights standard, right? So I need to understand that which steps are needed to be taken to combat discrimination and promote equality in accordance with international human rights standards.
Thank you very much. I think that question is quite clear. Justice Jacob, do you want to take it first, and then we can move along the panel?
Firstly, our constitution is completely consistent with international human rights standards, and we take into account international law in determining, for example, the meaning of equality. So that is the first step in the process. And therefore, when we apply human rights in our country, when we interpret what a particular human right means, not only the courts, but even students and all of us simply need to take into account international jurisprudence which guides us in relation to the direction in which we should go. And there is an example. There's an example of international jurisprudence in the Constitutional Court. I forget the name of the case now, but it was a trade union case where the court had to decide whether a soldier is a worker. And you understand the problem about military discipline and whether soldiers should be able to join a trade union and so on. And controversially, and if you Google whether a soldier is a worker, you'll find the name of the case, students, very easily. It concerns the provisions of the Labor Relations Act, and the court took into account the International Labor Organization's views on the matter, and taking into account what those international human rights instruments had to say, concluded quite controversially in those days that a soldier is a worker. So we take into account the human rights, but it's not separate from our Constitution. It's to interpret our Constitution and what it means that we place a great deal of stress on international human rights standards. And in all my experience, I've never found a simple conflict. But even where it looks like a conflict, if you think about it a bit more deeply, you'll find that it's not really a conflict. The conflict is really apparent. So it's, human rights are locally applicable. We're going to apply them here. But in relation to what we apply and the interpretation, we take into account international human rights standards as well.
Sir, your question answered. Thank you. Yes, Professor Kamga.
Thank you, Chair. Mine is not a question. It's perhaps a comment in regard of your question, simply to say, when you go to court, for instance, if you choose the litigation way to claim your human rights, if you are not happy with the result of the court, when you finish, when you exhaust local remedies, you can take the matter to the African Commission on Human and People's Rights, who will take the matter further, who will look into it, provide recommendations to your country to get your rights protected. That happens at the regional level. At the international level, the country is party to the International Covenant on Civil and Political Rights that have a human rights committee dealing with questions of human rights violations. So if, again, after exhausting local remedies, to the point that you get to the Constitutional Court and you cannot get the remedies that you wish or that you want, you go to international bodies by taking the matter to international organizations through the UN committee that will look into the matter and ensures that your rights are protected by giving a recommendation to the country to relook into the issue. That's perhaps what I wanted to add. Thank you.
Thank you very much. There you have it straight from the Dean. And there's also, of course, the European Court of Human Rights, where Sir Kentridge has also argued cases. I'm going to allow for one more question. Unfortunately, that will have to be the last question. So your hand was up. You may go ahead.
Oh, thank you very much for the opportunity, Chairperson. It's a great occasion. My name is Kanya Motsabi. I work in the law faculty. I was fascinated to hear Justice Yakub's response because perhaps without embarrassment to him, one of the prime examples of international law working itself into one of our cases is the case that I think, in which I think he wrote the majority judgment I think it was Grootboom. It wasn't Grootboom. It's a case dealing with the minimum core and whether the minimum core relevant under the International Covenant on Economic, Social and Cultural Rights should be used to read our Section 26 right of access to adequate housing. That was a great example. I was also curious to, and quite warmed to see Justice Sachs nodding somewhat vigorously concerning the Defense Union case, which I seem to recall he decided together with Justice O'Regan. And there too, that issue of whether a soldier is a citizen or not was very, very central. And in fact, if I recall, Justice Sachs's own statement in that case was that we'd rather have a soldier who's prepared to disobey an order as an exercise of active and responsible citizenship rather than blind obedience, and that the soldier who obeys blindly is actually a danger to our democracy and to the entire human rights system. So I wanted to share that comment as a way to perhaps solidify the point and reinforce it. Thank you very much.
Just one thing to add, to remind everyone that our Constitution makes it quite clear that no member of the Defense Force is obliged to obey an unlawful order. So if the order is unlawful, our soldiers are not obliged to obey in terms of our Constitution.
Thank you. Thank you very much. I think that concludes this session. We are right on time, I believe. I would like to thank my panelists again, Justice Jacob, Justice Mbata, and also Dr. du Plessis. Thank you very much for your presentations this morning and also for your contributions. I think this was a very valuable session. I would also like to thank the audience for their participation in the session. It was really heartwarming to receive all those questions from the floor. We are taking a break now, a comfort break, I believe, and at what time do we need to be back? Will you instruct me? Okay, thank you. Thank you very much again from the panel, and please enjoy the rest of the day. Thank you very much.
Thank you very much, Prof. Skuman. I would also just like to very shortly also sincerely thank Justice Jacob, Justice Mbata, and Dr. du Plessis for the insightful discussion. Thank you also to Prof. Skuman again for the facilitation of this part of the day. We now, as we mentioned, we're now moving into a very short comfort break. I would kindly like to ask that we're all back at around 12:30, so it's about 10 minutes. Then we'll be moving over to the handing over ceremony for the books. During the break, we'll be having some entertainment by Ms. Bayanda Makizi. So please be back at 12:30. Thank you very much.
Move to the books. You know, as Justice Yakub said, the students are the stars of this event. And I want to say one thing. And I'm happy that as the day was progressing, I could see more students coming. It's a very good thing. You know, in our lifetime, it's a privilege to have all these people around that we can talk to, that we can take a photo with. It's actually very difficult to get all of them at the same time because their diary is always full or always booked. People will travel the world just to have a look at them. You know, when you see people that the contemporary writers of the Constitution, activists, people who gave their soul, part of their life for the freedom that we have today. When we have the privilege at the faculty to have them, we should take that opportunity. It's an opportunity for you. I was very pleased when I saw students asking questions to the panel because it doesn't happen every day. It might not happen again next year. Although we will be begging them, they might be booked to go somewhere else. So I congratulate those of you who made it to this venue this morning. You will rarely see a panel like this one. I can tell you that. We won't be having so many events, but when we have an event at the faculty, we want to bring you the best. And it's tough to do this because you want to have our Vice Chancellor here. Sometimes it's not even in the country. And the nature of our guests need to have our Vice Chancellor with us. This is to say, when we pull a day like this, we should be very happy, not for us, the faculty, but for the students, for our students. Because as a friend once told me, when I was a student and I was privileged to be exposed to jurists of this caliber, someone said, we are lucky, we are seeing the immortals. Because for life, even after them, they are named. Those who have written judgment, those who have made history, those who have been the first female dean in a faculty of law, known to be whatever it was those years. We don't take that for granted. We do not. I'm telling you, we are fortunate and we should never forget this day. For me, their work, their judgment, reading. Many of you know by now, I hail from Cameroon. I did not know the law as I know it, but I learned, I studied here, and I learned everything through them, through their works, through their judgment. All over the world, when I speak about the history, the legal history of South Africa, I speak about all these people. Sitting here, being privileged to have a black female, black woman who is at the SCA, think at the history of South Africa those years. Where will you get that? So when you witness history on a day like this, we should celebrate that. Besides just celebrating human rights as in the Constitution, we are also celebrating our greatest people. Those, I'm not of those who like to come when people have passed on to celebrate them. Celebrate them if they are still alive. They know that we appreciate them, and we are very grateful to have all of you here. You know, because we are talking of these days, but perhaps because these were architects of the constitutions, perhaps without their work, we wouldn't be here. Okay? This is to say we should really appreciate and celebrate them whenever we have a chance. And law students and any student should be part of the celebration. Hence, I'm happy to see that now the room is getting fuller, which is good. It's good for you, it's good for your career, it's good for your inspiration. So perhaps with this, again, I want to thank all of them for coming here. I appreciate you, we appreciate you at the faculty, and we are grateful that you could find time in your very busy schedule to come here to be with us. If you want to know, we are not paying them. So it's just their goodwill to come and share this with you. They are doing this for free, and we should appreciate them. You know, at the same time, I want to also extend my thanks to you, Dr. Adere du Plessis, for capturing the academic voice as we discussed. We had a bit of conversation, but I want to say it, thank you. It was very well done. So not only me, the faculty, my team, we are so appreciative of you being here. Thank you again, thank you.
Everyone from the comfort break. So moving on to our next program point, I would like to introduce Ms. Vanessa September. She holds a Bachelor of Architecture degree and a Master's degree in Urban Design. Currently, she teaches part-time in the School of Agriculture and Planning. She has served on the board of Project for Public Spaces in New York and worked on a transformative public space agenda in Nairobi with UN Habitat. In 2020, she was appointed as the CEO of the Constitutional Hill Trust. Currently, she is the chair of the Albie Sachs Trust and producer of the Albie Collection. The collection is a curated conspectus of the life, love, law, literature, and laughter of Justice Albie Sachs. Please join me in welcoming Ms. September, who will be providing a brief background to the book collection that will be handed over. Thank you very much.
Thank you, Antoinette. It's the architecture, not agriculture, department. I don't know that we would know how to make agriculture happen in that faculty. Thank you very much for welcoming me. I feel since yesterday and the days before were leading up to this conversation. Thank you. It's a bit high for me. Thank you. The detail and the attention that's been paid to the detail for getting us here and having us be comfortable, we appreciate it very much. To yourself, Serge, and your team. Thank you. Thank you very much. So good morning and goeiemorgen, or is it already afternoon? There are few things in the world that gives us as much pleasure as receiving a gift. What would give you more pleasure, anyone, than receiving a gift? Giving a gift. And that's my pleasure today, is to be giving a gift to the University of the Free State. Last night at an informal dinner, the Vice-Chancellor, Francis Peterson, recognized guests at the table for their commitment to the transformation of our special and sometimes very mad country. The guests included Justice Albie Sachs and Justice Zak Yacoob. They both, as well as Sidney Kentridge, had the privilege and distinct pleasure to serve on the new Constitutional Court under the leadership of the now late Chief Justice, Arthur Chaskalson. Arthur Chaskalson, too, had spent much of his life in the pursuit of a just South Africa in which human rights, human dignity, equality, and freedom are our guiding principles. in a very abbreviated and very unfair summary for those of you who do not know about the late Chief Justice Arthur Chaskalson. I'll mention only 3 facts. That he was a lawyer, obviously, and that he had served as a lawyer in the team that defended Nelson Mandela during the treason trial. Have I got the trial right? And that he gave up a very lucrative law practice to create the Legal Resources Center, which still functions today, providing legal services to those who can't afford it. In 1995, he was appointed as the first president and later became Chief Justice. The lawyers in the room will explain the distinction at the time when everything was all very new, of the Constitutional Court of South Africa. When he retired from the court after serving only 12 years. Now, at the time, judges could serve for 15 years, especially if they weren't judges before. And the reason for extending their terms to 15 years is so that they could get a full pension. Chief Justice Arthur Chaskalson chose to retire after 12 years, which is the standard term for serving on the court. And by doing so, he opened the path for the now also late Pius Langa to become the Chief Justice, the first black Chief Justice of the country. So such is the generosity and the values of the man that money was to him irrelevant. The full story about Chief Justice Arthur Chaskalson, the lawyer, the judge, the man, can be read in this book, which is hiding under this very pretty purple cloth. What's it? Maroon cloth. Where was I? Yes, so that the book, which I think we should be handed over to Sergey and the law faculty. Can I pull the cloth dramatically? Well, wow, did I do that? So this book, one of, I think, 12, is available for the law faculty. Thank you very much for receiving it. Thank you. The Albie Sachs Trust, thank you. I've got a few more gifts, but if you want to wait with me here, you can. Otherwise, I'll give them all to you at the end of my presentation. You'll wait with me here. So we came into this book, the Albie Sachs Trust for Constitutionalism and the Rule of Law, which is also known as ASCROL. We were presented with a unique opportunity to acquire a few thousand copies of the books. The books were distributed to social justice organizations, university law libraries, and with the help of the Department of Justice and Constitutional Development, and I hate to say only Correctional Services. I don't know why they changed the name. But nevertheless, we gave them a few thousand copies of the books to hand out to public libraries around the country so that not only students here, but also people around the country could read about the work of the late Chief Justice Arthur Chaskalson. And we hope that your students will be inspired by the text that they will find in this book. And it is indeed also pleasing to know that we are contributing to your Vision 130 in the giving of this book. So thank you for your attention in this regard. So, but this is not all. When the court was first, like that advert, you know, when you buy something, that's not all, as they say. When the court was first started, it didn't have its own building. In 2003, after an international architectural competition, a young firm from Durban won the competition, and urban designers from Johannesburg, and the new court was inaugurated on the site of the old Fort Prison, the notorious prisons like Robben Island, East of Cape Town. The Fort Prison was in Johannesburg. The Fort Prison was first controlled by the British, who locked up the Boers. When the Boers got political power, they locked up the blacks, and in 1994, we said, okay, enough already. And the site was turned into Constitution Hill, a name given it so by the Chief Justice Arthur Chaskalson. And the new court was built there, and this book, which we would like to also gift to you, tells the story of the actual building. The building has many unique features. It uses 5 materials in its construction: concrete, glass, wood, concrete, steel, glass, wood. And who could guess what is the 5th material that the building uses, which this building doesn't represent? But then it's an auditorium. Any guesses? Light is the answer. So light we consider in architectural terms as a material. Passive cooling keeps the temperature comfortable. Integrated artworks in the form of gates and carpets and chandeliers and woven carpets, and this very special art collection, single-handedly and with the help of Justice Ivan Mohoro, Albie Sachs had collected. So it's a very unique court. A once in a lifetime, you must be able to see this court like going to Las Vegas. You must once in your life go and see the court at Constitution Hill. And all of those elements create this very fine environment in which the judges function, including the reference you made to the idea that the court speaks to legibility and accountability, and that the judges, when they're seated, they see a glass ribbon that runs along the building beneath bricks from the old awaiting trial prison that were used to incarcerate people and now protect our democracy or protect our human rights. So it's a very, very unique building, and you really should have an opportunity to go there. And yet, that's not all. In the making of the building, the architects also commissioned the making of a new font. And the font came as a result of a competition. And in my previous role, so the font was created using graffiti from the neighborhood and the old prison walls, nearby street signs. It's called the Face of a Nation font, and it was designed by a man named Garth Walker. He won a competition to design it. During my tenure as the CEO of the Constitution Hill Trust, we used the font to create this very beautiful document, which I would like to present to you. It is the preamble of the Constitution, using the Face of the Nation font, and printed on very special parchment paper, using also very special printing process. Thank you. So those are all the gifts for you. Thank you very much. You're welcome. And if you are lucky enough to get the two judges present here to sign it, I'm sure they would oblige. I have a special pen with which you can do that. And then you'd have to frame it. And you want to take a picture? Behind the table. Okay. And that's almost all. The preamble in this format can be downloaded from a website in answer to a question that came from the back of the room earlier. The website is called www.wethepeoplesa.org. You can accost me later and I can repeat this to you. The site also tells the story about the making of the Constitution and the Constitutional Court. The content and the material is shaped in a way that it is easy for people to digest. There are animations and pictures and graphics, and it's a site where you can learn more in bite-sized chunks about the making of the Constitution. And it also, Zach, helps people to learn more about the Bill of Rights and how our rights are outlined in the Bill of Rights. The team of people who are working for the Constitution Hill Trust, an organization I should remember to tell you that was actually founded by the Chief Justice Arthur Chaskalson and others. The intention of the organization is to inform people and educate people about the Constitution, and that is now actually happening. And the team now currently are focusing on the promotion and knowledge of the Constitution and its rights for particularly the community yourselves. Those under 35. 66% of the people in our country are 35 and under, and it will be your task, as has been pointed out by others who spoke before me, to help to understand what that Constitution is, understand your rights, help others to understand those rights, and for you to protect it through your understanding. So thank you for your attention, and now that is all from me. So well done.
Thank you so much.
You're very welcome.
Wow. How do we say thank you? Another big round of applause, please. We are very, very grateful for all this wonderful gift that I will tell you, they are precious gift, and we really have no word to thank you enough for this. You know, when Vanessa initiated the conversation with us on the availability of the Chacalson collection, we did not know that we were going to be spoiled. We are definitely very, very, very spoiled. And we are immensely grateful for this. Thank you so much. We were saying earlier we did not pay them. They're actually bringing us gifts. We can only say thank you and make use of them by ensuring that students, not only this generation of students, but even future generation of students, learn from this, they benefit from it. So we are, I will say, this is something that we will not forget. It will stay with us, the faculty, the university forever. We are extremely grateful. Thank you so much.
Thank you very much, Ms. September and Justice Sachs, for these wonderful and beautiful gifts. Something that doesn't really happen. We're actually slightly ahead of time. So I think it would be very nice if we can call forward Justice Sachs and Justice Yacoub, if possible, for the signing of the pledge. Or the pledge, or the... Thank you. Of the preamble.
Yes.
Is that fine? Should we make a space?
No, we can make a space here. It's more practical. But they can sign it here. It's okay.
Just before signing, Vanessa's asked me to add one extra item in terms of the font that makes this a very remarkable, extraordinary moment. Last week we were in Durban with the designer of the nation font that's used only in the Constitutional Court and for these very beautiful posters from the Constitution, from the preamble. And the designer, Garth Walker, said actually the key piece of writing that hit his imagination was the writing by Justice Zach Yacoub. Little knowing that he would be here with us today in Bloemfontein at this university, and asking him to sign a document he can't see. And what Garth Walker said was when he came to the court and he saw things written up on the big concrete plinths in front, the architect said, we don't want Roman lettering, boring, monumental stuff, we want human handwriting. Chief Justice Chasselson, will you write something? And he said there are 11 judges, 11 official languages, and we'll all write the words human dignity, equality, freedom. And he looked up and he saw Zach Yacoub's words, and there was a big B in the bottom line. And Zach's never seen his own handwriting. He invented something with guidance, with support, and somehow that B became the foundation of the font that's unique to the Constitutional Court. And now, Justice Zach Yacoub, as I'm talking to you, I think he will sit down and his fingers will be pointed towards the document, and he will sign the document. And I'm going to ask everybody to stand up and applaud. I only wish we had that wonderful singer here at this moment. Has she left?
Yes. Yes.
Can you sing something?
Yes.
Yeah.
Yes.
People should know this preamble, because this is the document that our call to action. Maybe I should stand here. So if you can see it, it's tricky to read this writing, but let's do it together. We, the people of South Africa, do you want to follow me or go together with me? Follow me, okay. We, the people of South Africa, recognize the injustices of our past. Honor those who suffered for justice and freedom in our land. Respect those who have worked to build and develop our country. And believe that South Africa belongs to all who live in it, united in our diversity. We therefore, through our freely elected representatives, adopt this Constitution as the supreme law of the Republic, so as to, and this is our job, heal the division of the past and establish a society based on democratic values, social justice, and fundamental human rights. Lay the foundation for a democratic and open society in which government is based on the will of the people, and every citizen is equally protected by law. Improve the quality of life of all citizens and free the potential of each person. Build a united and democratic South Africa, able to take its rightful place as a sovereign state in the family of nations. May God protect our people. Nkosi Sikelel' iAfrika. Morena Boloka Setšhaba sa Heso. Godsien South Africa. God bless South Africa. Mudzimu Fatsutshetsa uAfrika. Khosi Katekisa Africa. Thank you.
Testing.
For the day will be gracing us with another song as we move out. Thank you very much and see you back at 2. If everyone can just please take their seats. Okay, as I said, welcome again. We now move into the second part of the day, which is a public lecture on 30 years of human rights in South Africa, any reason to celebrate, which will be delivered by esteemed Emeritus Constitutional Court Justice Albie Sachs. I would like to welcome Dr. Russell Alley, which is the Director of Institutional Advancement at the University of the Free State, who will introduce Dr. Sachs, Justice Sachs for us. Thank you very much.
Thanks, Annelie, and good afternoon. Dr. Sachs is actually not completely inappropriate because he has an honorary doctorate from our university. And so we can use it in this context. So Dr. Sachs, a recipient of an honorary doctorate from the University of the Free State. I'm going to be very, very brief to introduce Albie, and which he prefers actually. And I'll tell you, I'll conclude with a story with Albie in the story. So I just want to mention three things about Albie, the three-part symphony. The first really is the attempted assassination of Albie in Mozambique. And it's almost 35 years, almost to the day, 7th of April, 1988, that they planted a car bomb in his car. And as Albie says, the South African security police got it wrong because in Mozambique they drive on the different side of the road. So they put the bomb on they thought it was the driver, but it was on the passenger side. But of course, he was very badly maimed. And it's a very formative period because it really shaped a lot of Albie's thinking subsequently. And one of the most important outcomes of that really is the book that Albie wrote, The Soft Vengeance of a Freedom Fighter. And for him, the best form of revenge, actually, was for the country to attain its freedom. It was not about to also plant bombs and to take out those who tried to end his life. So that's a very important event, an episode, which was part of Albie's political activism. The second part is Albie as the Constitutional Court Justice, which I think he would consider his most important work, because it really shaped the kind of country that we want to live in and the kind of democracy. And it's very appropriate that today, and I'm sure Albie's going to speak about that, this principle of constitutionalism, because we sometimes take for granted the importance of the Constitution, but more importantly than the Constitution itself, and I'm not in any way undermining the significance of the Constitution. We know it's wonderful and one of the most progressive, but the Constitution itself is grounded in this thinking of constitutionalism, which is very different to a different kind of system, and I'm sure you lawyers know this much better, parliamentary sovereignty. And we know the dangers of parliamentary sovereignty because the political parties that come into power don't necessarily serve the best interests of the people, and if there's not a constitution that can protect the will of the people, you can then have a sort of situation where parliament basically runs and takes over the country, but even parliament is subject to the constitution. And so that principle of constitutionalism, and of course Albie was one of the architects of what became the South African Constitution, and particularly the Bill of Rights. It's something that he has a very big part of his life's work. And the last really is life after the Constitutional Court, and he's been very active. And so I'm going to name drop a little bit. Albie is personal friends with George Clooney and Amal Clooney, and they have a foundation. And one of the important things that they do annually is an award that they give, awards that they give to defenders of human rights, those who put their life at risk to fight for and to protect the rights of others. And George Clooney had asked Albie to give his name to this. And in the end, again, in the spirit of Albie, and you can see the informality, that don't be fooled by the serious, intellectual depth there. He said, well, don't call it, Albie Sachs Awards. It's too complex, and let's just call it the Albies. And so there is a global award now that the Clooney Foundation, George and Amal Clooney, give every year. And the most recent was in 2023. I don't know if you went, Albie. It was a real glamorous sort of affair with all the A-list celebrities who pay a lot of money to be part of this event. And so it's wonderful that in life after the Constitution, Albie is still advocating for human rights. And I think the Albies is going to be one of the legacies, really, because it speaks to the person and the commitment to human rights, and some people who are prepared to give up their lives to advance human rights. And so we are really privileged to have Albie here with us to speak about 30 years of constitutionalism and constitutional democracy and where we are now as a country. So over to you, Albie.
I'm going to do the unforgivable. I'm going to criticize Sir Sidney Kentridge on the day when we're honoring Sir Sidney Kentridge. And for those of you not used to English protocol, I spent 11 years in exile in England. I never quite got it. But if you're a Sir, then you Sir Sidney. If you're a Lord, you Lord Kentridge. Some of the correspondents spoke about Sir Kentridge. And I think I got it right, actually. It's Sir Sidney, but he's my friend Sidney. He's somebody who watched me growing up. There are not a hell of a lot of people alive today who can remember my growing up. He is one of them. And that comes into the story, and it comes into the unforgivable part of the story, because Sir Sidney claims that he was the person who persuaded me to become a lawyer. My dad, Solly Sachs, General Secretary of the Garment Workers Union, fighting the state, fighting the employers. He fought my mom, he fought his children, a great fighter. 24 cases of his came to court, including a number of leading cases. Wanted his little boy, Albie, to become a lawyer, and Albie wanted to become a doctor. And people say, Albie, what are you going to do? In my matric year, I'm going to become a doctor, I'm going to become a doctor, I'm going to become a lawyer. Something happened. And Sidney says he gave a book to my dad, Solly, to pass on to me, and afterwards I became a lawyer. Now, those three events did happen, but there wasn't a causal connection. The book he gave was called From Hammurabi to Holmes, and it consisted of ancient texts from the Mesopotamian civilization up to Oliver Wendell Holmes in the US Supreme Court. I never looked at it once. If ever you wanted something to turn you off doing law, give them From Hammurabi to Holmes. But somebody else gave a book called Darrow for the Defense. Now that was exciting. That was the lawyer hero. I afterwards came to dislike Darrow. The cases all turned on him, not on the litigants, not on the people, but on the lawyer. But somehow that did the trick. And I mention this because Sidney was there in a way from the beginning. And my dad, the union, would brief him quite frequently. Many of his first cases came. And that wasn't purely because of accident. Sidney's father, Morris Kentridge, had been locked up in the Old Fort prison. during the labor struggles of the early 1920s. So there was a tradition there already of resistance, of opposition, of law that can be used to oppress people, but also legal mechanisms can be used to defend the rights of the people. I'm going to fast forward to March 1994, when I took, if not the most important personal decision of my life, one of the most important. It's a month before the first democratic elections. I'm so excited. We're achieving our dream of one person, one vote equality in South Africa through the franchise, destroying the political system of white supremacy. But I'm feeling very uneasy, and I can't quite understand. Why am I feeling so awkward? It's a strange emotion, and then I realize what's eating me up. We're going to have elections. We're going to have a new government, almost certainly Mandela president. Who's going to be the first Minister of Justice? And there are 4 members of the ANC Constitutional Committee on the National Executive, the NEC. There's Zola Skweyiya, Kada Asmal, Dalla Omar, and Albie Sachs. Who's going to be the first Minister of Justice? And I thought, have I been all my adult and even half my juvenile life fighting to wonder, will my telephone ring? It upset me. All the passion, the idealism, the fighting for freedom, for justice now gets converted into a possible job, and will I be the person chosen? It distressed me. It seemed to be almost challenging my whole spirit, challenging me as a human being. And I took a decision. I'm not going to enter into the political game. I support the political game. Political parties are important in the world. They can play a very positive role. They can play a very negative role. They can play positive and negative and positive. But I felt, been there, done that, made a contribution, we're getting freedom, at least at the political level. Now I can do something different. I can get out of law. And I tried to get out of law several times before. Practiced at the bar nearly 10 years in Cape Town, into solitary confinement, once 168 days. 2 years later, solitary confinement, again, torture, sleep deprivation. But I was an advocate at the Cape Town bar. It was thrilling work, it was horrible work, awful laws, some decent judges, great colleagues, terrible colleagues. I'm going to England, I'm going to exile, departure permit, I'm going to get out of law. I'll do a PhD first. Give me time, justice in South Africa. How does a judiciary that speaks the language of justice and freedom and rights function in a racially stratified, oppressive society like South Africa? Got my PhD, looking for a job, not very useful for anything else except law. Now I become a law teacher. Mozambique gets independence. I come to independent Mozambique. I get my courage back in Mozambique. Time of the revolution, transformation, change, progressive slogans, long live the struggle of the oppressed people of the world, long live the emancipation of women, down with racism, down with tribalism, down with regionalism. Power to the people, people's power. And I'm looking for work, and I become a law professor. I actually loved being a law professor. I loved teaching. But I wanted to get out of law. And eventually, Samora Machel closes down the law faculty. He says they're all emerging as bourgeois people interested in making money and not in advancing the rights of the people. Easy to close down a law faculty, not so easy to open up again. And I end up in the Ministry of Justice helping to develop a new legal system. Wonderful work. And then I'm blown up. And I think now I'll get out of law, but I go to England. Hey, maybe I can do something that'll be useful. What do you want to do? Somebody said. I said, I've been offered a job at Warwick University for 3 months and somebody else in Auckland. What would you like to do? I'd love to work on a new constitution for South Africa, preparing. Fine. We have an office in University of London, not an office, a toilet. We can convert it into an office. We'll get funding from Ford and Swedish International Development Agency, and now I'm working on that. Still in law. We come back to South Africa. Now I can get out of law. Well, not now, not now. Now we've got to make a constitution. So we're involved based at the University of the Western Cape. I asked people, which are the 2 universities that did the most to promote the creation of the South African Constitution? I've kind of given it away now, and people say, UCT, no. Wits, no. Stellenbosch, no. Pretoria, no. Durban, no. They give up. UWC and the University of Potchefstroom. UWC, the University of the Left. Jacques Gerwel. Dalla Omar sets up the Community Law Center. We put on research projects and workshops, electoral system, regionalism, social and economic rights, affirmative action, land, on everything. Should we have a constitutional court? All based at the Center for Development Studies and the Community Law Center at UWC. Potchefstroom, de Klerk's University, with some very bright, sharp intellectuals there supporting his side. And now it's March 1994. What am I going to do? And I take the firm decision then. I'm not standing for Parliament. We had a meeting in a hotel in Devonshire Hotel in Joburg. Packed. The first list for the elections. So exciting. The branches have voted. To get there 9 o'clock, you have to catch a 6 o'clock plane. To catch a 6 o'clock plane, you have to get up at 4 o'clock. I'm tired. The air conditioning is not so good. We're going alphabetically. Sax is way down, and I'm scared I'm going to fall asleep. They'll call out my name. Are you willing to accept? There's silence. My name goes on, and I wake up, I'm a member of Parliament. So I'm pinching myself. Don't fall asleep. Don't. And it comes to Sachs, Albert Louis Sachs. Please withdraw my name from the list. The only thing that interested me in law was possibly getting onto the Constitutional Court. That for me would be a continuation of my life at a very special level. If I didn't get onto the court, then I really would have got out of law. I wouldn't be sitting here now today. Maybe I wouldn't have got an honorary degree from University of the Free State. Or I might have got an honorary degree for filmmaking or something completely different. The process of being chosen for me was very painful. I thought I would just walk in there, I had a PhD, a book published. I'd be an external examiner at Dar es Salaam University, University of Harare. I'd worked at Eduardo Mondlane University. I thought all of these Africa-centered activities would give me a boost. But there was a problem. John Dugard, very brilliant, wonderful person who's made an enormous contribution to rights, is another candidate. And so there's a campaign to knock out Albie Sachs so that John Dugard. John should have been on that court. He should have been on that court. The vagaries of history. In any event, we're waiting until it's October. I hear afterwards from Kader Asmal. He was a wonderful friend to have. Sparky, bright, clever, knowledgeable, and indiscreet. Little secrets that other people would hold back on, Kader will tell. And Kader said the clerk bitterly opposed your name. The president had to choose 6 people out of a list of 10. So Arthur Chaskelson, 1, 4 existing judges, and it turned out it was Ismail Mohammed, Tolly Madala. Dalla insisted on Tolly Madala, not very experienced. He didn't want all whites to come in then. And then it was, I think, Richard Goldstone and Johan Kriegler. Maybe Laurie Ackerman at that stage. Didcot had to get on. I think Goldstone had to get on. There had to be place for 2 women. So it was Kate O'Regan and Yvonne Mogoro. And now there are 2 places left. Didcot gets one. The last one, will it be Albie or will it be John? It was sad and unfortunate. It was a battle between the 2. And eventually, I'm on the court. And who's sitting on the court, the first court with me? Sidney Kentridge. We were so happy to have him there. It's not an accident that South Africa, racist white supremacy South Africa, produced so many outstanding lawyers, a small number of whom were very, very progressive. It's partly because apartheid tried to rule through law, using law, the past laws, legislation being passed all the time, special courts being set up. And the price they paid for that, a kind of semblance of fairness, was that we could resist through law. And so Arthur Chaskelson, to my mind, was the greatest legal mind of the late 20th century, early 21st century. Not because Arthur was clever, he was very clever. Not because he was brilliant, he was very brilliant. Not because he had that X factor that lawyer, he had all that. But because in South Africa, the law was so central to the conceptualization of racial supremacy and to the destruction of the system of racial supremacy. And he was the person who had that strength of knowledge, understanding, character, to manage and handle that huge transition from a constitution that was overtly racist to a non-racial, non-sexist democracy, turning the whole thing upside down and using the law to achieve that. And having Sidney with us, first of all, he is a lovely person. Not all great lawyers are lovely people. I'm not going to mention names of some exceptionally brilliant lawyers who are not lovely people. They're fine people, but not lovely, not easy, not warm, not gracious, not funny, not smooth, not eloquent, just brilliant and sharp. He was all of those positive qualities, but with a lovely, fluid, gracious manner. I remember when we were speaking about computers, this thing called computers the judges would have to get. And Sidney said, I'm only a temporary member of the court, and he puts his hand in his pocket, he takes out a big fountain pen, and he says, this is my computer. He's not going to go in for this. It didn't stop him from writing wonderful legal opinions, pressing legal arguments. Zach, I think, did a wonderful job about the role of Sidney in the first case of ours to be released, to be delivered publicly. And Zach was chatting to me during the interval. He knows all our decisions are collective. We all contribute. But people place their mark. You can tell certain judges could never have been written by Albie, or never been written by Johan Kriegler, or never been written by Ditkot. Your personality comes through, your way of structuring, the idiom, the feel. We're not in that sense generic. We're individuals on that court. But everybody feeds in, everybody contributes. And he was lovely in conversation. We would go round and round the table, round and round several times. He said afterwards, I heard him say to somebody in England, it's the most extraordinary court he's ever had any dealings with. And one reason it was extraordinary, and this is going to some extent, what's a nice word for dent or counteract what Zach said on the Mhlungu case. The case, if you remember, Section 241(8), it's right at the back, transitional arrangements. To avoid having to swear in all the judges again, start everything from scratch, new constitutional order. The transitional arrangement, those in office, judges, magistrates, carry on in office. But what to do about part-heard cases? And the language was part-heard cases are to be dealt with as if the Constitution didn't exist. So Sydney is the first person to speak at our table. It wasn't around then, it was an oval table. He says, the language is very clear. The results are unfortunate. It would mean a case that started before the Constitution came into force. Capital punishment could still be applied. Group Areas Act proclamations could still be in force and so on. And you just have to deal with it through executive action. Laurie Ackerman, I agree. Arthur Chaskerson, I agree. Somebody else, I agree. Albie Sachs, I disagree. Why? I couldn't say why. I couldn't articulate why. But my feeling, my whole body was saying, this is a new era. This is the era of freedom. We can't allow even the tiniest bit of that racist, patriarchal, oppressive, divisive legal world to continue into the new era. It's a new dawn. This is not like a tax provision that transits from one year to the next year. This is South Africa reconstituting itself profoundly, fundamentally, and we are the judges up there. I just knew it overwhelmingly. Then Yvonne, I want more time to think about it. They're also unhappy. Kate, I want more time to think about it. Pius, I want more time to think about it. Ismail Mohammed, I want more time to think about it. Now, it was an interesting division. The new judges, the very new judges, Tolly Madala, think about it, the law professors, we were all unhappy. The superbly experienced, very progressive Sydney Kentridge saying the words of the Constitution have a literal meaning, and it's better you don't mess around with the words that the framers of the Constitution used. He came through as a strongly literalist at that stage. And in the end, Ishmael wrote a judgment, and he was the one who pushed the purposive. So Zach was absolutely right. The first case, he stressed values, the values of the Constitution must apply to statutes. But when it came to the text of the Constitution itself, he said we must apply the literal test. And that's when the majority of us, I said the words are very clear, but they clash with the very clear words of the Bill of Rights. And if different provisions of the Constitution clash, you don't say the one triumphs over the other. You manage as well as you can the core elements of both. And the core elements of a transitional provision are much weaker than the profound fundamental rights of the Bill of Rights. So it deals only with not the substance of the law and the procedures. It deals with the procedures. The procedures don't have to start again, and I reconcile the two. Ishmael wrote expressly using the term purposive approach, why we have a constitution. And I must say from then onwards, the first convert to purposive interpretation was Laurie Ackerman. And Johan Krechler came over very quickly, and Ditkot came over very quickly. So and I mention this because 10 years later, we had a workshop to celebrate 10 years of the Constitutional Court, and it was based on famous cases. And Sydney was invited, and he spoke about the case of Liversidge and Anderson during World War II, where internment without trial and so on was upheld by the majority of the House of Lords, and there was one dissent by Lord Atkin saying that the law is not silent in the midst of war. And that dissent became internationally famous. And Sydney was insisting he used the literal meaning of the words. So Sydney remained a literalist as far as I know at the age of 101. He's still a literalist. But fortunately and overwhelmingly and completely, the purposive approach. So for those of you who are not lawyers, it's not an unimportant distinction. The literalist is, we used to work with dictionaries, and you'd have Oxford English Dictionary interprets the word as something. Then somebody else would go to Chambers from America, slightly different interpretation that supported your client. We've done away with all that literal interpretation. We interpret the words of the Constitution in the context of our history, in the context of the suffering of the people, in the context of the hopes of a better society, and in the context of the Bill of Rights and the fundamental values and the preamble and the structure of the Constitution as a whole. It's a very different way of looking at things. Sydney then came into the story of the court through a completely different portal. We wanted work for the artwork. Yvonne Magoro, we've just been yesterday, Vanessa and I, to Galeshewe in Kimberley, where she grew up. And we actually went to Robert Sobukwe's house, the house where he was banished to, and it was Robert Sobukwe who encouraged this young woman to become a lawyer. And she and I were in charge of the decor for the court, and partly responsible for choosing to place the court in the middle of the old Fort Prison, in the middle of our history, turning the negative into positive, turning swords into plowshares. And we're looking for work. We've got 10,000 rands, which spent it on one picture by a painting by Joseph Ndlovu, which we had made into a tapestry showing humanity. So I approach William Kentridge. I remind him, he doesn't need reminding, his dad was on our court. Can he offer something? And he's got a work, it's called The Dogs of War. It's from a play that was put on with a handspring puppet people theatre, Ubu and the Truth Commission, set in South Africa, and it's got 4 ferocious-looking dogs' heads. And the body consists of a little leather case with those clips that we used to have, clasps for the body. And William explains he was looking for a body for these puppet heads, and he saw this little case that his dad had left behind when he went to London. It wasn't the latest sartorial fashion for a barrister in London to have a stodgy little 1930s style leather suitcase. And he said, that can be the body. So it's a wonderful connection now in our art collection. And some years later, I'm visiting London, and the only time I could see Sydney would be to go to his house for breakfast. And at first it would be Felicia's wife, who would prepare and chat. Then when she became ill, Sir Sydney, I like to say Sir Sydney fried eggs for me. How do you like them, Albie? And we would chat. And he said, do you know the story of the suitcase at the incorporated into the Dogs of War sculpture? I said, yes. You left it behind. He said, yes, there's a story behind that little suitcase. He said, when I appeared as junior counsel with Bram Fischer for the first time, some years earlier, he gave me that case. It was a tradition then. You'd give your junior counsel, later on it became a little silk bag. He gave me that case. Wow, I said, from Bram Fischer, one of my super duper heroes. I got such a lift when the plane lands here, and I look out, look out, look out. We told about beautiful Bloemfontein. I just want to see Bram Fischer written up there, and I love the sculpture outside. And then I'm sinking into my seat, and he didn't say, and that's not all, but in effect. And the case in which I appeared as junior to Bram Fischer was the case of Sachs versus Voortrekker Pers. And the Sachs was my dad, Solly Sachs. And the Afrikaner nationalist government loathed Solly Sachs with a particular venom because it was many Afrikaans-speaking white women in the union. Afterwards, people like Lillian and Goy joined. The grandmother of Rosie Jardine, who was in the news recently, joined. And they tried to destroy the union. And they defamed my dad, made up a whole lot of lies. He sued them for damages. The last little coda on this story, in fact, involves de Klerk. A few years ago, before de Klerk died, of course. And I'm invited by the de Klerk Foundation to speak at an annual conference that they have. I'm first up, and I speak about the basic structure of our Constitution. It's based on equality, equal rights, non-racism. And once that's guaranteed, then you have space for cultural diversity. It's the right to be the same that guarantees the right to be different. If you use difference to destroy equal rights, then skin color, gender, language become weapons of power and disempowerment. So there's got to be equal access to the basic rights and services in our society, and then you speak your language, you pray to your God, you express yourself in the ways that you want. And then I mentioned growing up with these Afrikaans-speaking women in the Garment Workers Union, and they were warm and friendly and full of fun, Johanna Cornelius and Hester Cornelius, and so my picture of Afrikaans people was not horrible in the way we got from our English language school, of slightly not fully developed, not fully civilized people. It wasn't that at all. On the contrary, it was full of laughter and joy and energy and positive feeling. So I'm leaving that workshop afterwards, and I see de Klerk blocking my way. Now, he'd never been friendly to me. He'd fought bitterly against my nomination by Nelson Mandela. He'd always been very cold. When I arrived there, his wife, so lovely, so warm, so generous, very stiff. En nou praat hy Afrikaans met my. He's blocking my way. And he said his father had been a school principal in Klerksdorp, and the Nationalist Party took him out of that to counteract Solly Sachs in the Garment Workers' Union. And his father went on to become Jan de Klerk, Minister of Labour, who passed laws banning black people from going on strike. Laws, he said, which he had repealed recently. And he shakes my hand and I leave. I thought, South Africa, what a weird country in terms of different interactions. Let me come to the concluding part of my presentation. It's basically on this theme. I'm asked all the time, and I speak about it all the time, all over the country and internationally. People say, Albie, they look at my arm, you were blown up, you were in solitary confinement, you were in exile, you were stateless for 7 years. Look at the country, look at the problems, the inequality, the racism that continues, the crime, the stealing. Is this the country you were fighting for? And I pause. And I say, yes. This is the country we were fighting for. But no, it's not the society we were fighting for. And for me, that's a fundamental difference. Not a lawyer's difference, a reality difference. We got a country. We didn't have a country before. We had a territory. The whites owning just about everything, dominating everything. Black people, Indian origin, colored people in group areas. It wasn't a country. It was a land of alienation and division. We got a country. And we got a constitution. We got a country through the constitution. That day on 27th of April, 1994, when we voted, in other countries, when Ghana got independence, there was a date, the British flag came down, Gold Coast, the New Ghanaian flag went up, the band played, people clapped. Right through Africa, independence, new anthem, new flag, ceremony. In South Africa, 22 million people voted on our Independence Day. You can't be more participatory than that. And for the first time, clearly, unequivocally, black people were in the majority, the overwhelming majority. There was one elderly man I'll never forget. He was brought to the polling station in a wheelchair. He wanted to vote before he died. When Adelaide Tambo asked me to help her, she's in Parliament as a speechwriter, I said, Adelaide, you write your speech. I will maybe help polish it up a little bit. And she came up with something I would never have said. Her first speech, she said, my one regret as I stand up to address this House is that my late husband, Oliver Reginald Tambo, and I think she's going to say, didn't live to become president of South Africa. She said, my late husband, Oliver Reginald Tambo, didn't live to vote. It was that tremendous day when we began to constitute ourselves as a nation through the vote. And people said, so many people, reactionaries, one man, one vote once. Democracy is not for Africa. It took us Europeans, 1,000 years to become civilized. I thought civilized, World War I, World War II, concentration camps, millions gassed, Holocaust, civilized, conquering the world, trampling on people's rights, burning down their homes, stealing their land, civilized, gallows, whipping, caning, civilized. And the civilized people in our country, Oliver Tambo and Nelson Mandela and other people I'm working with that broad vision. I always felt with Oliver Tambo, it was one of the great things in my life to be able to work closely with him. We couldn't have been more different He growing up in a rural area, deeply religious. I growing up near the beach, cosmopolitan Cape Town. I'm very secular, he's deeply religious. We adored each other. When he had to prepare a speech for the World Conference on Religion, he asked me, secular Albie, to help him write it. Not the religious desk. They would say, we know this Catholic and that Methodist who can support us. He felt he would get something from inside from me. And I always had that feeling with him. The white people in South Africa are too trapped in their narrowness, their selfishness, their tight vision, to ever imagine everybody living as equal in one country. We African people who've suffered so much for being who we are, we believe it is possible. And it's not a concession to the whites, it's not being nice to the whites. It's an expression of our deepest internal beliefs and our intense humanity. It will be a victory if we get a country for everybody. It will be a victory if we get whites in parliament. It will be a victory if they become part of a common society. I always felt that with him. And it hasn't been one man, one vote once. We're now preparing for the 6th general elections. And they're going to be free and fair. And for me, the biggest contribution that the ANC made historically to South Africa was to be the primary drafters and movers of the Constitution, which would allow the ANC to step down if they lose. And I remember when the results came out of the local government elections and Jacob Zuma was the president, he's standing up on a high platform at the IEC offices. The results are out. ANC has lost Port Elizabeth. It was in Kaberge then. What? It's lost Johannesburg, including Soweto. What? It's lost Pretoria, unimaginable. And he says, we accept those results. And I remember 3 young black women came in with big signs saying, remember Shezi. And they bundled out. They're not thrown into jail. They're not beaten up. I felt this is extraordinary, South Africa. The Constitution, in that sense, is holding. The election results are being accepted. And there's freedom of speech and freedom of expression. That comes with and from the Constitution. We've got a lively press. People speak their minds. It's not a fair society. It's still a very unequal society, and inequality closely connected with race. Strongly, powerfully, unacceptably so. We're not a fair society. And we're not a safe society. Why should it be wonderful for me if I'm traveling in some country somewhere else in the world that I can walk around at night freely? Why should I feel special joy? This is what everybody should have. We can't do that in South Africa. It's unacceptable. But we are an open society. People speak their minds. Before, if I saw somebody here, nobody's writing down my words, but if I saw someone writing down my words, I'd say special branch. Now it's because they think, oh, that's interesting, maybe I can use it in an essay. In a way, it's a joy for me that young people don't know what it was like. I, as a privileged white, thrown into jail without charge, trial, tortured by sleep deprivation, by torturers who'd learnt their techniques from the French in Algeria, without charge or trial or anything. My thesis, Justice in South Africa, published by University of California Press, published by Heinemans in England, banned in South Africa. If Justice Joyce had a copy in her possession, you could go to jail just for possessing a book by a banned person. We are living in a different country. It's even I, privileged as I was. And that's huge. And part of me is joyful and delighted you don't know what it's like, because you're not carrying that burden. And you are resisting, and quite correctly resisting, the continuation of the injustices. If you were carrying on your shoulders the burden that your grandparents and great-grandparents have, you would be immobilized, you'd be terrorized. So you've got the freedom to demand change, to organize for change, to vote for change, to speak for change. And this is what I celebrate. It's when the Constitution is under stress, does it hold? And so far it's holding. I don't know another country in the world where you have a public protector, makes a report, the judiciary says the report is binding on government, a commission has to be set up, the government spends a great deal of money on a commission to investigate its own failures, and then asks for more money, and more money, and more money, and that's all provided. Where else in the world do you have a country where a president, a sitting president, spends a whole day in the witness box being cross-examined about his work as political leader, and another whole day being cross-examined about his position as leader of government? This is extraordinary. I lived in Mozambique, I mentioned that, 11 years. They were astonishing and wonderful years for me. But I also learned people's power, one-party state, revolutionary transfer, seizure of the land, the property, and everything, which I supported. I thought was marvelous, uniting the people to bring about real change. It left no scope for opposition. Opposition didn't disappear. It went underground, got picked up in the Cold War. Civil war, bitter, terrible civil war. I lost an arm. Mozambique is full of people without legs because of landmines, child soldiers, hundreds of thousands of deaths, millions of refugees leaving the country. We avoided that in South Africa. I'm so glad we avoided that we have a country. We have a country that's left. Mozambique hasn't recovered from their civil war. So the Constitution then gives us mechanisms to withstand and deal with and respond to the many unacceptable features that we have here. If you like to pick up on what we were told at the beginning, the vengeance aspect, my soft vengeance then is not to employ the methods that they used against us, but to ensure that the Constitution becomes even more meaningful, that the instruments the Constitution gives for change become even more meaningful. I just want to conclude. I can't conclude without maybe saying a little bit more about the Constitutional Court. I was so irked the other day when I was speaking to a judge who had attended a conference of judges recently, and he'd commented on a speech that was made that was very dismissive of the early Constitutional Court of South Africa. Hey, I want to get up and, how dare you? Okay, we're not entitled to that kind of instinctive defense. But one of the comments made was about the judges all trained in Cambridge with their Anglo kind of outlook. What? Yvonne Mokgoro from Galeshewe, Unisa, Pius Lange, also studying at night. Arthur Chaskerson didn't study abroad. Go through them all. Even Laurie Ackermann, when he studied in Germany. And he very interested in the German Constitutional Court, one of the great courts. And he always had German law clerks, and even when he got sick during the certification case, he got German measles. My PhD was at Sussex University. Kato Regan's PhD, University of London, on labour law. So none of us were from that kind of background. The only judge I know of that generation who studied in Cambridge was former Judge President John Schlope, who wasn't on the Constitutional Court. It's a very ironical kind of throwaway line in relation to us, but much more than that. How many of you in this room have been to the Constitutional Court in Johannesburg? Zach, you've been there, I believe. Okay, it's very, very, very few. It's a wonderful place to visit. But we chose to place the court right in the heart of number 4 prison. Not in Cambridge reality and imagination, in South African experience, where our leaders have been locked up. And we had a competition, and the competition entry that won was on the theme of justice under a tree, traditional African way of resolving disputes. A building that would be friendly and open and transparent, like we heard earlier on. That had a feeling for African style of social organization without being beehives, formalistically like theme park. We didn't use the language of decolonization then. It was in our heads. We rejected the old logo from the old South African Republic. We rejected the blindfold lady with the scales of justice. We have people under a tree as our logo. We rooted our imagination in our struggles for our freedom in our country, and it was African people who led those struggles. When I'm introduced as a human rights activist, I say no. I wasn't a human rights activist. I was a freedom fighter. Different. I was immersed in the struggle, and I was part and parcel of the conceptualization of a new constitution in the struggle, not as an outsider enabling people to get their rights, but as a participant in the freedom struggle. We placed the judges at a level in the courtroom, eye level, the same eye level as counsel addressing us, deliberately. People are not coming to the court to plead to oracles up there. They're coming to demand justice in the Constitution. We rotate the seating every year. I don't know if it's still done now, every term in the court. No hierarchy in the court. We dropped my lord, my lady. We dropped that. I think it's the only senior court in the country where you not call my lord, my lady. We wanted to be respected for the quality of our judgments, not because of the title that we had. These were decisions we took very early on. And frequently, I remember in particular cases where people came from a rural area, they came from a human settlement nearby, the presiding judge would get a law clerk to interpret certain things to the people visiting there. I just felt so proud to be part of that very, very African court. And even our thinking, it's no accident the capital punishment case, the term Ubuntu cropped up in 6 out of the 11 judgments with a very strong expression by Yvonne Mogoro. Cambridge knows nothing about Ubuntu. They can learn something. These are transferable things. So the people who fought hardest for our democracy in South Africa were black African people. The people who resisted democracy were white people claiming the most, claiming to be civilized. That was the inversion. The people who insisted on dividing the African people in tribal groups in Bantustan because that's their custom, were the whites, the people who wanted unity amongst all the black people, with great respect and love for the clans, for the language, for the groups and so on, but all equal as Africans, were the freedom fighters. That document is as African as you can get in terms of its provenance, in terms of the people who fought for it, and in terms of the core values. There are huge areas that need a lot of, and I now really will conclude just with this, where we need African values of human solidarity, of mutuality, of interdependence, to enrich our common law and to enrich our thinking. We need to Africanize, if you like, or South Africanize many aspects of our whole legal system, but not to attack or undermine or diminish the greatest achievement of the black majority in this country, which is in our Constitution, in its character, its vision, its quality. And I have enormous respect for the Matlingosi's, brilliant legal minds, sharp, critical. I love to work, I want to work with them. They contribute to debate, they ask important questions. But there are few constitutions in the world that have social and economic rights spelled out. And this, in fact, has brought me to the lovely concluding moment. When Justice Zak Yacoob wrote the Grootboom judgment, he was writing one of the great judgments of our age, of our era, in the world, and it's quoted all over the world. So it's not just the logic. We all agree on the logic. And you're quoting the right sections of the Constitution. And you're justifying it legally. But it's more than that. It's the quality of language. It's the way he locates it. It's the way Mrs. Grootboom now becomes the center of the legal vision. It's not the state functionary. It's not even the land owner from whose land they were evicted. It's Mrs. Grootboom. Because our Constitution requires that. It's shifting the focus of the law away from the powerful towards the marginalized. Law as something that can mitigate, can assist, can open up, keep democracy functioning. And in that sense, the contribution you made, Zak, was of enormous value to the legal conception of the role of the judge and the relationship the judge has and the collegial court has with the community. So I'm ending up then by saying, thank you, Jack. I've now coined a new word in the English language, and it's called, with the benefit of blind sight. I'll repeat that, with the benefit of blind sight. Blindness can mean lack of sight, of vision, but it doesn't mean lack of heart, lack of contact with the heartbeats of others, with the pains of others, the dreams of others, the emotions of others. And in that sense, Zak Yacoob, who's here with me today, and my wonderful colleague from the Constitutional Court, represented that wonderful vision of blind sight. So with the benefit of blind sight, I can say I sit here now as a very, very, very proud South African jurist who had the honor of working on the Constitutional Court, of working in the days when we didn't just solve disputes, we established a methodology, a style of work, intensive scrutiny and mutuality amongst ourselves, and an institution. It's not just a court, a bunch of people, it's an institution that needs to be protected and developed as an institution. And I'm so proud of the decisions that court has taken over the years since then. I'm so proud of our judiciary. I'm proud of the Supreme Court of Appeal that used to be seen as the bastion of conservative thinking, representing the old way of doing things and not willing to move, and now a source of creativity and diversity and vitality. So the answer then is there anything to celebrate in South Africa today? There's lots to be angry about, there's lots to complain about, there's lots that has to be announced, but there's lots and lots and lots to celebrate. We've got a country, we've got a constitution, we've got rights, we've got instruments that we can use. Use them.
Thank you very much, Justice Sachs. It was truly insightful to hear about your history and your perspectives and your knowledge, and thank you so much for sharing all of that with us. We do have a few more minutes left for some questions and answers. I just want to check on where the microphones are. If you can maybe just raise your hand. I think there's two questions there. Will it be easier for Judge if we do one question at a time to
No,
a few?
take three.
Three, okay. So we'll start there with the gentleman there at the back and then the lady here. Yes.
Thank you so much. Good afternoon, everyone. My name is Tato Makhodielo. Justice, my question to you is with regards to, I'm right here, my questions to you is with regards to what you said in fighting for the country, but not necessarily the current society that we have. What do you think we should do to take or to put the society to an extent or to a point where it fully shows the struggles and the pain that our past fathers and brothers fought for in apartheid, and how can we really show it in this current society that we've basically moved away from the apartheid regime and are now into a new generation?
Thank you. Yes, and then just this lady here. Perhaps if you can just stand up when you ask your question.
Good day, sir. First of all, it is an honor to be in your presence. Thank you so much for your contribution. Mr. Sykes, earlier you said that we need to Africanize our South African legal system while not neglecting the reality of the black majority in the country. And so bringing it back to universities and South Africanizing universities, I think about how there are still signs that are not that are still in English and Afrikaans translations, and certain posters only having Afrikaans translations, and unlike our school slogan, which at least has 3 translations, and having certain statues of the past still up, etc. I would like to ask, how does the human rights and law sphere hold any responsibility to dismantle symbolisms and systems and structures that echo apartheid past in our country? Or does that not link to human rights and the law side of things and is rather an effort that should be given to social scientists?
Thank you. And then I believe there was one lady there. Yes. You can just maybe stand up. I don't know where the other microphone is. I see you and I will get to you in the next round.
Okay.
Thank you.
Good day, Justice. My name is Bokang Fako. I'm a postgraduate student at the law faculty. We have the 29th of May coming up, so it will be incorrect to not leave the space without talking about democracy, elections, and voting. So my question is basically around those lines. 2024 is currently what is perceived as a super democracy, because we have nearly 70 countries that have elections this year, and about 7 of those countries are African countries, with Africa going into the 7th January election. So my question is, I spent this past weekend with various politicians, activists, and public servants from the SADC region, and the general consensus and what I'm gathering is that the youth, and not just in South Africa, are completely disgruntled with voting and participating in elections because of the current, they're disgruntled because of the poor service delivery by the current administrations, and because politics and governance are now demonized and perceived as corrupt, morally starved, and an unethical thing to participate in. So my question to you as an activist, as a lawyer, as a person who has participated significantly to where South Africa is now, how do we get the young people to embrace our participatory democracy and actually recognize the significance of voting in elections? What would you say to a disgruntled person who is not a Tintwalo about participating in elections and democracy? Thank you.
The youth are disgruntled. How would you encourage them to participate
Youth.
in democracy?
Yeah.
Thank you for the questions. I think, yes, Justice, I'll leave it at that for now.
Yeah. That last question, I should be asking you that question. For quite a long time, I've been avoiding questions like that by saying, people say, Justice Sachs, what advice would you give to the youth of South Africa today? And I'll say the only advice I would give to the youth of South Africa today is don't listen to the advice of old people like me. Be as cheeky, irreverent, challenging, idealistic, impossible as we were. And I still believe in that to quite a large extent. The only thing I'd like to pass on, though, is treasure idealism, treasure hope, treasure belief, whatever it is. Treasure collegiality, some people call it comradeship. Treasure ideas, treasure values, whatever you do, however you work. And part of me is sad you can't experience some of the elation and joy we had in the struggle. You can't, because the situation is just so different. But it also means you're not experiencing the dread, the collapse, the pain, the psychological distress. So I'm glad you don't have to go through that. I think the only broad advice I can give is I look back on my life, I look back on my world, the world I grew up in. I think I've had an extraordinary life. I survived the bomb, I survived the prison, I survived the isolation. I survived the pains of internal battles and problems. I survived personal unhappiness. I saw our country changing. For me, it's huge. I'm sitting at the University of the Free State with an audience like yourselves. You take yourselves for granted. That's fantastic. This was unimaginable. Unimaginable. Not even dreamable then. In a sense, just that you are sitting asking me hard questions, that's the realization of my dream. So it's not offering you mechanisms, ways forward. It's just encouraging you to work with others, to hold on to these very, very core beliefs, not to be, our son wants to make money, lots of it quickly. That's his right. As long as that doesn't become the be-all and end-all of his life, you know, there's much more treasure in human relationships than there can ever be in wealth and gold and capacity to buy and so on. The question of transforming the universities, again, compared to even the Free State was when I came here 20 years ago, it's a different place. It's a different space. And to my mind, a better, more South African space. By South African, I mean including everybody in a kind of more representative way. It doesn't mean excluding anybody. And it certainly doesn't mean excluding Afrikaans speakers. For me, it would be a great achievement for people who speak Afrikaans at home to feel comfortable at this university. But not if the only comfort is dependent on some kind of heerskappy, some kind of dominance, some kind of superiority. Then it's ugly. But people should be able to speak their language. It can be Setswana, Sesotho, isiZulu, Xhosa, it can be English, it can be Afrikaans. It's a great language of our country. And so I don't feel that people who are Afrikaans speaking, if they're black, white, or brown, should feel in any way inhibited from using their language. If there are problems because we have textbooks in English and Afrikaans, we don't have textbooks in Sesotho, then that's dealt with not by suppressing Afrikaans, but by promoting Sesotho and in other ways diversifying like that. I won't get deeper into the language question. I know it's been very painful in Stellenbosch. The fights are still, struggles are still going on there. But I start off from the position that Afrikaans is one of the great languages of our country. It's spoken by millions of people in different parts of the country. It's the main language of Cape Town and the working class in Cape Town. There's also been great literature, poetry, Afrikaans folk singers have made a huge contribution, and we've got to see it as a source of richness, not as a source of something that has to be combated. At the same time, if people feel their Afrikaans-speaking identity gives them rights above anybody else, exclusive rights in any way, then that has to be combated, and very, very firmly. Going back to the past, I suppose it's my generation, in a way, is angrier at the disappointments of what's happening in the country, but also less angry. You get angry if the name of a movement, of personalities, of a vocabulary is used for selfish, divisive accumulation and so on. We feel it more than others. And we know it was overwhelmingly poor people in this country who gave so much for the freedom that we enjoy now. At the same time, it is another country. It's another country, and it's not standing still. Every time I come to UFS, I just see further steps have been taken to South Africanize. You deal daily with the problems of areas of tension and exclusion and so on. I don't know. I would have to ask you. You would have to advise me. The one sadness I have, however, is the loss of idealism. And it doesn't even have to be over politics or human rights, but it's idealism about life and living. And that is a sadness for me, that something that was so marvelous. You would travel to Canada and I'd meet the ANC representative there, and I'm just out of hospital, and you'd say, Comrade Albie, the Boers have Africanized you, you've got scars like Tambo. And just such a fantastic bond. And he says, you know, look at Ottawa here. It's got 3 rivers, he says to the Canadians. Can't you give us just one? Now, it's a kind of a South African style and language and a sense of connection. We're living far from our country. We've been in exile, we've been in jail, but we had that sense of the future will be better, and we were engaged in a marvelous, wonderful project. Now we see a lot of realization of that project. Individuals have failed, institutions have failed, but this is a changed South Africa, and you've got to make sure that change continues. And you've got to be inventive, that new generation. Other speakers have said that same thing. You've got to be creative. You've got to get well beyond the things we dreamt of and felt would be enough. Would I wish I was 20 again? I don't know. There's a story about a 90-year-old Supreme Court judge in the United States, and he's coming down the big steps there, and it's a slightly, not slightly, it's a little bit sexist, the story, but he sees some very attractive young woman passing by, and he says, "Oh, to be 70 again." Now I can't make that joke anymore. I don't know what's funny about that joke. I used to roar with laughter when I heard that joke. So I can't put myself in your shoes. All I can say is that I feel joyful about the life I've been able to live. To have seen the extent of transformation and change, and to have learned to look to the long term, to understand that things take time. We learned that in the struggle. To appreciate what's positive, to find the good in the bad, not to be afraid of denouncing the bad in the good. The only problem is if I become disappointed and in despair, then it's finished. If even Albie is pessimistic, then it's over, because there's something in me, I don't know if it's inborn, my experiences, when I was blown up, I felt fantastic, I survived the bomb, I only lost an arm. And that positivity and that optimism is self-fulfilling, if only I can transmit that to yourselves. And negativity is also self-fulfilling. You go down, you allow yourself to go down. You envelop yourself with hopelessness. And we kept that positivity, and it saw us through. And it did, in that sense, replicate itself. And that's why, and I'm really going to end now, when I stepped down from the ANC, I resigned first from the NEC. Nobody was interested in my resignation. They had small things like bombing campaign against the elections, elections to prepare for, the right-wing Afrikaners threatening a coup, and Albie Sachs wanting to resign never made it onto the agenda. So I just announced it. I left my branch, but I didn't feel I was leaving the struggle. I was continuing the struggle in its most pure, beautiful form through the Constitution. Because the best of us got invested in that Constitution. The women who fought for women's rights in Parliament, getting non-sexism in the Constitution, a strong gender dimension all the way through. The workers in the unions who practiced democracy, electing their shop stewards, looking after funding, choosing people not because they spoke your language or came from your village, but because they fought for the workers. They got powerful rights for workers in the Constitution. Even the land issue, which is another whole thing in itself, and the demand was to entrench existing property rights, and they're not entrenched in Section 25. You go through step by step, social and economic rights, rights for the child. It's, in that sense, called the most progressive, if you like, the least neoliberal constitution in the world. We've got millions of people on social grants. That's not neoliberalism. It's not unproblematic, but that's not neoliberalism. We've got a quarter of the population living in RDP homes. They're not wonderful homes, they're not great communities, but they've got water. When there's water, they've got electricity. When there's electricity, they've got sewage. There have been real, profound changes, and the Constitution has been on the side of change. It doesn't realize itself, it's not self-realizing. In that sense, it's just a piece of paper. But that piece of paper can be activated, can be made real, and lawyers, those of you who are studying law, you can be in the front line of using the Constitution as a set of a visionary document with institutions, with work you can do as lawyers in different ways, afterwards as judges in securing the rights of the people. Thank you.
Thank you. Thank you very much, Judge. Unfortunately, we reached our time. For those that might still have some questions, hopefully you can find some time to engage with our guests afterwards. As a last program point, I would like to call forward Dr. Russell Ali, who will deliver the word of thanks for us. Thank you very much.
So on behalf of the Vice-Chancellor, unfortunately he had to have another engagement. So on behalf of the Vice-Chancellor, we really just want to thank everybody who has participated in an extraordinarily wonderful, exhilarating, thought-provoking day. We want to obviously thank our guests who came and participated, some all the way from Tshwane, from the Republic of KwaZulu-Natal. So we really want to thank Justice Zak Yacoob, Justice Yvonne Mabatu, Dr. Adri Duplessis, Professor Elsabe Skuman, who came all the way from Pretoria. We want to thank our own Oprah, where is she? Vanessa September. I'm not going to ask you to look under your seats because there's nothing there. Thanking Vanessa September for all the wonderful gifts. So there's Vanessa. And of course, we want to, special thanks to Albie Sachs for this wonderful address. I mean, those of us who just had this, privilege to hear his journey, it really gives real meaning to that expression that the political is personal and that the personal is political. Because we forget sometimes that we kind of sort of separate as if politics is out there and we here. And politics is really about the people, about people's real life and living conditions and the realities that they actually face. And so it was wonderful to be taken on that journey that Albie took us on. So thank you for that. Then, of course, we want to thank the law faculty who put all this together. The dean is there, Professor Serge Kamga. It's been such a wonderful day, and I'm sure your faculty and those who came out really appreciated all the work and the effort that goes into that. These things just don't happen automatically. Where's Aldi? Yes, I saw Aldi. Yes, she's still here. Or she's busy organizing. There's Aldi, who put a lot of this together. You know, all the logistics, all the program, making sure that people get here in the hotels, and of course their meals. And so, Aldi and the team, thank you so much to be able to have this wonderful day. Our talented and wonderful musician, Bayanda Mkize, maybe as we leave, she's still with us, or she left. Yeah, maybe maybe this can be the party, you know, as we sort of leave. I'm sure we would want to hear it again. I mean, it's one of those things that sticks with you for a long time, and it's just wonderful to hear that. So thank you very much. Annelie Deman, for the program director and making everything flow, and from the Center of Human Rights. I think it's a wonderful, it's also just a way of showing what the Center for Human Rights at the university does, the kind of work that it does, and this is just testament to that work. So thanks to Annelie for all her work and commitment to this event. And then, of course, finally, all of you. I mean, you really the stars, so give yourself a round of applause for coming and participating. And of course, hopefully this is going to inform us as we move towards one of the most consequential elections that we're probably going to have this year, 30 years after our democracy. And I'm sure you're going to make wise choices and wise decisions. So go well, everybody. And if I've left someone out, apologies. You know, as they used to say, all protocol observed. Although that had a very different meaning during COVID, right? All protocol observed. But have a wonderful day and go safely. Thanks, everyone.
I think if you maybe just give it some time, our guests might be willing to wait outside to just take a few pictures and a few engagements if you would like to give that a chance. Thank you, everyone. Bye.